and the court will impose only those sanctions that are appropriate and proportional under the circumstances. Before imposing any sanction, the court will make specific findings on the record. In addition, the court may consider any remedial measures, including immediate suspension of video transmission for the hearing in which the violation occurs, with proceedings continuing on an audio-only basis, and disqualification, if necessary, narrowly tailored, of the news organization that filed the request in order for electronic media coverage of the court proceedings for that hearing from serving as pool camera operator in this matter, where such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. Any such remedial measure would be considered only as a last resort and only to the extent necessary to address the specific violations at issue. Council will have an opportunity to provide input before the court makes any final determinations regarding sanctions. The court values that input and will give it careful consideration. I want to be clear that these measures are intended to preserve open and transparent courts while ensuring fairness to all parties, and the court remains fully committed to the presumption of open proceedings under the applicable rules. Rather, these measures exist to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. With respect to media coverage in the courtroom, the court offers the following additional guidance to assist everyone in navigating today's proceedings. The pool camera has been relocated to the rear of the courtroom. The camera operator shall not zoom in on any individual seated at council table. When council tables are filmed, the camera must remain in a wide shot that includes all individuals seated at the table. Attorneys and witnesses may be filmed individually when standing at the lectern or seated in the witness box. I would also ask counsel to be mindful that microphones are located throughout the courtroom and may pick up conversations. Counsel may wish to consider using screen protectors on laptops and taking reasonable steps, such as covering one's mouth when speaking, to avoid the inadvertent capture of private communications, whether by camera, microphone, or those present in the courtroom. Third, the court wishes to address the camera operator. At this time, Mr. Josh Demick, could you come forward to the lectern? Could you please state your name and spell it for the record?
Yes, my name is Josh Demick, Josh-Demick.
Thank you. My intention is not to cause you any embarrassment or discomfort, although it's probably not feeling that way on your end. I simply want to ensure that the expectations for today's proceedings are clear. During today's hearing, what is your primary role?
My role is to cover the hearing that we have going on this afternoon, and I have read over the decorum and the EMC as well. My plan is to solely focus on the individuals that will be speaking up here.
All right, you anticipated my next question, which was, have you read the December 23rd, 2025 standing decorum order, which you have, and I appreciate. And do you understand the guidelines as they relate to your responsibilities today, including the additional guidance regarding camera position at council table and the filming of attorneys and witnesses that I just put on the record that was not in the decorum order?
Yes, Your Honor.
All right. Do you need any additional time to review the order or to reposition the camera to ensure full compliance?
No, Your Honor.
Do you anticipate any difficulty complying with the order or today's guidance?
No.
All right. Thank you, Mr. Dimick.
Thank you.
Before I let you go, as I just asked questions of the pool camera operator, Mr. Dimick, I'll turn to counsel. I do wish to weigh in on what the court has just done.
No, Your Honor. Thank you.
Thank you.
Yes, thank you, Your Honor. Richard Novak for Mr. Robinson. May I speak from here?
Yes, Mr. Novak.
All right, thank you, Your Honor. We appreciate that the court, on its own accord, moved the videographer. I don't know where the still photographer is, but we continue to be concerned that any video images of Mr. Robinson during court proceedings, close-up images of Mr. Robinson during court proceedings, interfere with his right to a fair trial. I think I heard everything the court said about the videographer, but the still photographer is still seated in the same place where they were last week. And we would ask the court to order the still photographer not to take any photographs of Mr. Robinson's face or person during the hearing, in the same way that the videographer has now been ordered to be focused on the court, the witness, if somebody's testifying, counsel at the lectern, or generally the people seated at counsel, what the court referred to as counsel table. We do not want to see still images again of Mr. Robinson's face in the media with more speculation about meaning of his facial expressions or the lack thereof. And so we really appreciate what the court did on its own, sua sponte, I guess we would say. But we have the same concerns about the still photographer.
All right, and before I address that, any questions as it relates to Mr. Dimick? I want to excuse him to go back. Standing in front of the court is no fun. I recognize that.
I was just trying to keep him up there as long as possible.
I see. All right, Mr. Dimick, thank you so much.
Thank you very much.
All right, before I address that, I'll allow the parties to be heard before I address what Mr. Novak has brought up as it relates to the still photographer. To the state.
Your Honor, I think Your Honor is appropriately concerned about the video, any close-ups of Mr. Robinson. I'm not sure that a still camera presents the same concern. This is a public hearing, and I think that that it's appropriate that still photography be taken. I don't know that it raises the same concerns that Your Honor's raised with the video.
Thank you. Any other party wish to be heard?
I'll be brief, Your Honor. Michael Judd on behalf of the news media. We agree that with what the state has just said. The concerns that I understand the court trying to address involve the capture of moving lips that can be used by lip readers. We have dealt in the past with inadvertent overhearing of actual conversations. I don't think still cameras present that same issue. The idea that a participant in a public hearing, including the defendant, cannot have their image captured by a still camera because a facial expression is somehow too much to let the public see, we simply don't agree with. It is, of course, the court's prerogative to set the guidelines that it believes are appropriate to balance these interests, but it will come of no surprise to the court that the news media believes that that particular measure of saying even a photograph of a defendant in a public courtroom is too much to allow without threatening fair trial rights in a way that goes beyond that balance. We think that's too far.
All right. Mr. Novak, I do have a question for you. Has there been a violation of the decorum order by the still photographer in any of these proceedings?
I am not aware of violations by the still photographer, but I am very aware, if I may, of what we believe is unfairly prejudicial media content based on the images. And video images, yes, can be embedded in electronic media, but still photographs also are still appearing. Still photographs from the courtroom are still appearing in print media and in less, what we've referred to as less formal media channels. So we are still very concerned, and I don't understand why there would be any even marginal negative access to the public to this hearing by the still photographer being in the back of the courtroom and taking photographs of the court, meaning Your Honor, of witnesses on the witness stand, if that's what the court's going to permit, of counsel. I don't have a problem with that. But we continue to have grave concerns of huge photographic lenses being focused on our client. And the results of that, and I'll just make a representation to the court that while we were in court last time, Mr. Burt and I both received, literally in real time, long ranting voicemails from people who were watching the proceedings. Now that was on video. I received another one of those calls today referring to my client's facial expressions from somebody who decided to leave a long, aggressive message on my office phone. And I'm very concerned that even still images of Mr. Robinson's visage in the courtroom are going to interfere with his right to a fair trial. And we've reached the nature of the media coverage where Mr. Robinson feels like he may have to make a choice between two of his Sixth Amendment rights. And that's the right to a fair trial and the right to be present. And we want him to be able to have both of those rights and the way, and all of his rights, and the way he can exercise both his right to be present and his right to camera to where the video camera was ordered to be.
Thank you, Mr. Novak. Thank you to all parties. I appreciate your input. This is an important matter, and the court takes it very seriously. I note that there has been no violations of the December 23rd, 2025 decorum order by the still photographer. That being said, this court wishes to exercise caution and will request that the still photographer go behind the bar, to the bar being the separating lower wall, and reposition his camera at that place. I appreciate the patience of all parties as we do this. And again, this court is balancing open and transparent courts with the constitutional rights of all parties involved. All right, while that's occurring, I'll turn to the state. The court would appreciate a brief update on the status of discovery.
Your Honor, Chad Greenender for the state. To date, we have shared with the defense 100% of what we have received from law enforcement. With that said, we have been informed late last week that there is approximately, well, there are several terabytes of digital evidence from phones and other digital devices that the State Bureau of Investigations has in their possession. We are collecting a 20 terabyte hard drive to two of them, one for us and one for the defense. We did receive a letter, I think this morning, from the defense outlining their expectations with respect to how that would be received, original form, and more specifics as well. So we're in the process of coordinating that download onto those hard drives of the digital evidence that's been collected, and we will provide that as soon as we receive that and it's downloaded to the defense. We are still working with law enforcement on the download of approximately 30 days of all of the surveillance video at UVU. We were told it was approximately 300 terabytes, and that's being downloaded 24/7. So that is still in process. So we're actively working on that and looking forward to collecting that and passing that along to the defense. It will need to be shared in some sort of similar fashion, I'm sure, with respect to hard drives.
Thank you, Mr. Gernander. Does defense want to be heard?
That is correct, Your Honor. Stacey Visser on behalf of the defense. We are in communication with the state about what we believe is missing at this point. And we are anticipating a large amount of digital discovery in the next few weeks that we will need to process.
All right. Thank you.
May I supplement this conversation, Your Honor?
Briefly.
Thank you, Your Honor. We've kind of divided up discovery responsibilities, and mine is to address what I'll call non-digital forensics. So there are many items of seized evidence that have been sent to various law enforcement labs around the country without getting into the details. We have some very, what I'll refer to as summary reports of those evaluations. But as the state attorneys know, we're going to need all of the underlying data, notes. These relate to things like DNA and other forensics. So if we haven't provided them with a very, very detailed list of the types of documents we need, we will. But I think, and Mr. Grenender could speak to this in more detail in terms of the status of that, but I think that's another big chunk of materials that presumably the state attorney's office has not received yet from law enforcement. And so obviously they haven't had a chance to give it to us, and we haven't had an opportunity to look at it or to have our own experts review those types of materials.
Thank you, Mr. Novak. All right, before the, Mr. Grenender.
We'll make a point to follow up on that with the law enforcement agencies. We'll communicate with defense counsel on that, Judge.
I appreciate the cooperation between the parties. Before the court proceeds further, it's appropriate to address the record. The court notes the recent filing by victim representative Erica Kirk involving the statutory right to a speedy disposition of the charges under Utah Code Section 77-38-7 sub 2. This court raises this issue solely to ensure that the record accurately reflects the statutory scheduled trial or other significant criminal proceeding. The court must inquire into the circumstances asserted as the basis for delay and must consider the victim's interests in timely resolution together with the defendant's constitutional and statutory rights. The court emphasizes that the defendant's rights to due process, to present evidence, and to receive full and impartial consideration of all arguments remain paramount and undiminished. The court's responsibility to balance these interests faithfully and without preference to any party. As previously stated on the record at the September 29th hearing, justice demanded that both of these principles, the rights of the accused and the rights of the victims, be honored without compromise. With that framework established, the court will hear briefly from counsel concerning how you propose proceeding today.
Thank you, Your Honor. Richard Novak, again from Mr. Robinson. We're prepared to continue with Mr. Gray's testimony. We did file what I captioned a renewed request that this court proceed under a particular section of the Utah Code to refer this motion to the Attorney General. So it's obviously up to Your Honor to decide if the court wants to address that renewed request in writing now or at a different time. I do want, whenever it is the court's view that it's timely, to address the issue that the court just brought up, which is how the court, well, what I want to address is how the court will manage the question of whether Mr. Robinson needs more time to prepare for the preliminary hearing. So the court got an update on the status of discovery. The court noted Ms. Kirk's filing, which of course we are all aware of, and we understand her rights as the representative of the victim in this case. There are challenges under Utah law when the defense needs to communicate to the court the details of its diligence in terms of preparation for a hearing, because we're not going to make a public filing of work product. And I'm sure the court understands exactly what I mean.
Yes.
So what I'm saying is the court brought up the filing and the significance of that for future proceedings. We're going to need to have, if I may, what I would call sort of a case management conference at some point about how the court will manage our need to be able to share with the court the status of our work, which we believe is confidential and privileged, in light of the fact that every time we file something and ask the court to designate it as private, we have counsel for the media trying to unseal it. And we also don't intend to disclose to the state the status of our diligence. And so I'm not asking the court to address it now. I guess I'm just trying to put a Post-it note on somebody's list. It's certainly on our list. And we didn't really intend to bring that up at the outset of today's proceeding. But since the court mentioned Ms. Kirk's filing, it just seems like the right time to mention that. So we're prepared to proceed with further testimony from Mr. Gray and keep going with the evidentiary hearing unless the court wants to address what I captioned our renewed request.
Thank you, Mr. Novak.
Thank you.
To the state.
And Your Honor, the state's prepared to go forward with the evidentiary hearing. We are prepared also to address this renewed request. If Your Honor would like to do that at the outset, I would suggest that Your Honor set a time limit on that argument so that if, assuming that that motion's denied, that we can move on with the evidentiary hearing. We've got witnesses who've been subpoenaed. They're ready to testify.
All right. Well, I appreciate that update, and I do want to give some guidance of how today's hearing is going to go, and both parties have touched upon that. Based on the record before the court as it relates to the evidentiary hearing, and in order to ensure a fair, orderly, and efficient proceeding, the court will proceed as follows. First, we will address what Mr. Novak just brought up in regards to the referral to the Attorney General's office briefly, and you'll see why I say briefly with my next statement. Counsel will have until 4:30 to present evidence, including cross-examination and any redirect. Motions for supplemental briefing are denied at this time, as the court finds the issues adequately framed for today's proceedings. These parameters are not intended to limit any party's substantive rights, but to keep the proceedings focused and free from any unnecessary delay. Upon the close of the evidence, the court will proceed to argument. Each side will be allotted 15 minutes. Mr. Novak, or to any of the attorneys who would be making closing arguments, if you intend to reserve time for rebuttal, please allocate your time accordingly. This court will conclude at 5 o'clock. And in addition, the court anticipates issuing its ruling via WebEx in order to give the evidence and the arguments presented today the careful and deliberate consideration they warrant. That proceeding will be scheduled at the conclusion of today's hearing. And so, counsel, with that in mind, we will turn to the motion to refer or the motion concerning the Attorney General's office. I will hear from both parties. It is your time. I am not putting constraints on who you call, what questions you ask in part, but keep in mind these time constraints as we address this issue. Mr. Novak.
Thank you, Your Honor. We filed what we captioned the renewed request because obviously at the last hearing, we brought the request verbally. Obviously the court's read our renewed request and our points and authorities. We received the brief written by Mr. Ballard, which is very clear and very well written, and we understood the views expressed there. We just disagree fundamentally on what that code section means. We disagree fundamentally on the suggestion that there's a separation of powers problem. It is ultimately this court's responsibility to ensure that parties are represented by conflict-free counsel. Obviously, in the legal profession, there is an initial expectation that counsel will avoid conflicts. But there are always situations where a party needs to bring a conflict on the other side to the court's attention, and the court has both the statutory authority and the inherent authority under the common law to do something about it. So we do believe that this is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance. That seems to be a gentle way to say that the state is at least disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you, Your Honor.
Turning to the state, Mr. Ballard.
Your Honor, it feels like Groundhog Day. Here we are, we've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that. So as we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does. And I'm happy to walk through the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr.
Thank
Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court's defendant's renewed request to refer the pending motion to disqualify to the office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution, and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings regarding a prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under Section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one piece of the record? Your Honor referred to the statute as 1718A, but I think it's actually been renumbered. It's 17-68-304 is the current citation.
Agreed.
Thank you. I appreciate that correction, and that is correct. I appreciate that, and to clarify the record, thank you to both parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
All right, the court will take a very brief 3-minute break in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we will proceed. It is now 1:38. We'll come back at 1:41. Court is in brief recess.
No. Not that I can remember. That's completely,
Okay, well, I'll represent to you that it was 5 days after the hearing on January 21st. Does that refresh your recollection at all?
oh, are you talking about after the hearing? I'm aware of that, yes.
Okay, and
Yes.
how did that come to be? Because you testified that your office has no involvement in the investigation.
Well, it was a point that you had pointed out, and so out of an abundance of caution, I believe it was Mr. McBride that decided to go ahead and do that.
Okay, and have the adult child be interviewed.
Yes,
So it's your understanding that Mr. McBride advised SBI to do that interview?
that's my understanding.
Understood. Okay. You also testified on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written policy?
I did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death, did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when
And
I'm
that's
sorry.
what we did.
When I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
There was a subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so, yeah.
And so what I take from the return on the subpoena, if I could call it that, is that there isn't any memo to the file. There's no legal analysis. There's no memorialization of the decision that you made that there's neither an actual conflict or an appearance of a conflict.
No, there's not.
You mentioned when you were testifying at the last hearing that you are the president-elect of SWAP. Could you just remind the court what SWAP is?
SWAP is a statewide association of public prosecutors or public attorneys and prosecutors. It's basically a lobbying group with respect to legislative matters that affect prosecution.
And how long have you been a member of SWAP?
For about the
As long as you can remember?
the 3 years that I've been county attorney, I've been a member, a board member of SWAP.
Okay. And are you familiar with a document that they produce called Utah Prosecutors Best Practices?
I know that they have that document, yes.
Did you consult that document with respect to what your office should do in connection with the potential conflict of interest or the appearance of a conflict of interest that we're discussing?
I don't believe I consulted it. I relied on my 25 years of knowledge of conflicts and so forth.
Your Honor, what I would like to do, if I may, is approach Mr. Gray with a document that I'm just going to mark for identification as Exhibit I, and that's because we've previously marked for identification A through H, if I have my alphabet correct. And
Yes.
if I may pass one up to the court, I will, if the court needs that.
No, feel free to approach Mr. Gray and present
right,
Exhibit
thank you.
I.
Gray, I'm handing you something that's been marked as Exhibit I for identification only. Oh, I'm sorry, of course. Have you seen this document before?
I've seen it, yes.
All right,
I mean, there's a lot more than just conflict in our best practices.
absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes,
And you see what I'll refer to as general standard 1.30 conflict avoidance.
yes.
All right, could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
What do you take to mean the reasonable appearance of conflict?
There has to be a real actual conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that there's an appearance to the public?
Objection. This calls for a legal conclusion, Your Honor.
Witness,
Mr. Novak.
well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means. But I don't think the witness's opinion about it is evidence.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood. Mr. Gray, why don't you turn to page 3, and that would be standard toward the bottom. 1-3.3C. Do you see that?
Yes.
Okay, could you read 1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
All right, Mr. Gray, I want to ask some questions about the decision to file a notice of intent to seek the death penalty against Mr. Robinson and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk, all right? You state in your opposition, well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure, I don't want you to get hung up on my nouns, for when your office decides to seek or not seek the death penalty in a case?
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's
But
right.
my question is there a policy, a procedure, a protocol, something in writing?
No,
Okay, and is it your view that it's your decision alone because you're the elected county attorney?
yes,
Okay, and in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
yes,
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
no.
Are you saying that that prosecutor was specifically excluded?
Now, maybe I misunderstood your question. I thought you asked whether or not we discussed her status as a
Then let me
witness
back
there.
up, because it was a bad question if you didn't understand it.
Okay.
Those are the rules, right? Okay. So you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes,
whoever the state accused of committing that crime.
yes.
All right. And
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty.
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team. But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
All right. Now, what you're saying is that and that you discussed that with all of the team members, even if informally.
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about. That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty.
Yes.
And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was president at two different press conferences.
So there was one on the 10th and one on the 11th.
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time we filed charges, if that's.
Okay, but the question I asked you was, had you discussed with the governor your intentions?
At some point, I did. I told the governor that I intended to seek the death penalty.
And was that before Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
Did you tell the governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
Are you aware whether the member of your team told the governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members, a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well, so they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States went on national television and said, I hope he gets the death penalty?
I had heard that he said that, yes.
And that was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
And you knew before you filed the notice that the governor thought it was an appropriate case
Yeah.
and the president thought it was an appropriate case.
Yeah.
Did Mr. Patel express his views?
Not that I recall. I mean, he was doing the bidding of the president. So, but I did find it a little interesting, Governor Cox, because he plays no part in the decision. So,
Did you tell Governor Cox after he made those public statements, this is not your decision, this is my decision?
no.
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
Right. And the person whose child we're talking about is a long-standing, experienced senior member of your office,
Yes.
right? Now, it
Yes.
was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building,
Okay.
which is fine with us.
Yeah,
Thank
but I'll
you.
be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Did you?
Not yet. Not yet.
To the state, Mr. McBride.
I'm going to refer to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes,
Have you ever met Prosecutor A's child that was present at that shooting?
not that I could remember. I could have in passing, but not that I can remember.
Did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
0.
Did that child's presence have any effect on your decision to seek the death penalty?
0.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge, and I believe that the death penalty is entirely appropriate in this particular case.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes,
Did her presence affect the decisions you made on September 10th at all?
no,
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
it had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case, in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and they said, yeah, we usually wait. But so I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case. And so I had to hurry and call them before that, say that's not true. And within a month, I filed the death penalty. But it creates unnecessary angst with families of victims. I knew that this particular case was, talk about publicity. It's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that. And so that Erica Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did. Is
Yeah.
that right?
Yeah.
To avoid that uncertainty, speculation, and so forth.
Yes.
Was that decision made because Prosecutor A's child was present at the event?
No.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was,
What year?
it was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but I mean, because I had handled,
Had you met him personally and interacted with him personally? Or
no,
you just knew who he was?
yeah.
Okay.
I mean, at some point after I won the election, I met with him and others to determine who.
Understood. But at that time, when you were making that campaign commitment, was it because you knew Prosecutor A?
No,
Was it because Prosecutor A had an adult child?
no.
Okay. Decision making. As far as the decision making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes. In any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about, the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many? I mean,
No. My question is, having attorneys
yeah,
appear
no,
at the
not unusual at all.
do you know which attorneys went?
Yes. I know that I went, Mr. Grunander went, you went, Ryan McBride, and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
I mean, major decisions. No, I mean, what comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was quite frankly foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. I mean, every time there's a motion, obviously the team is working on it. We work on it together. But I mean, as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, is it fair to say that the most important decisions are yet to be made in this case?
Yes,
That includes trial strategy,
yes,
preliminary hearing strategy,
yes,
any plea negotiation.
yes.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No.
I should say aside from this motion.
Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No,
Do you believe it will affect the prosecution in the future?
no.
Why not?
Because this is somebody that happened to be there. That has, what we're concerned about is the evidence supporting the charges. That's first and foremost. And that has nothing to do with somebody that happened to be there. Quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received a you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to the scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
Okay. You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back. And I've done that for, over 30 years in my practice. I'm capable of doing that.
I researched it where?
Case law and so forth. Again, I do not believe that there's any conflict whatsoever. I made that conclusion. I stand by that. Out of an abundance of caution, we certainly notified counsel out of an abundance of caution. And I think that's the appropriate action to take. So again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor. And I didn't see how this does in any way.
Okay, if I can have just a moment. You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there. Yeah.
When did you learn that those people were there?
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all.
Okay.
Maybe a hello or something out on occasion. But as far as I know, I'm not even sure that they even live in our ward at all at this point.
Okay. Thank you.
All right. Mr. Novak.
No, thank you, Your Honor. I don't have any redirect at this time.
All right. And as previously discussed, may Mr. Gray be excused?
For now, yes.
Thank you. Thank you, Mr. Gray. Mr. Novak, your next witness? Or I'm sorry, Ms. Nestor. Your next
Your Honor,
witness.
at this time, we were going to call the adult child, but I believe that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point. I think it would be appropriate to hear whether or not we close the hearing or at least come up with some ground rules about preventing any photography or mentioning of her name, however the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. And I'll hear any additional argument or statements prior to making a ruling?
Your Honor, Ryan McBride for the state. We do move to close the hearing for the testimony of the adult child. I think the rationale that I explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the defense has accepted here, we have shown that there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated to closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right, so the media, the prosecution cited to the media, did you want to weigh in?
The media does not object to the closure of this portion.
Thank you. The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts Regarding Closure of Portions of the Evidentiary Hearing on the Motion to Disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A, an adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied. The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child's witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. Court will be in brief recess for 2 minutes.
All right.
his child and target his child. For that reason, I would ask the court to oppose the testimony of Prosecutor A.
Defense.
We join in that motion.
And is the media wishing to weigh in on this portion?
Again, the media does not object to the closure of this portion.
All right, thank you. Let me address this issue. And a lot of this is repetitive, but being that this is a motion being made, I will put on the record the preamble to my ruling. The court has reviewed the parties' prior arguments and the material submitted in advance of today's hearing, including entitled Proffer of Facts Regarding Closure of Portions of Evidentiary Hearing on Motion to Disqualify Utah County Attorney's Office. Defense has requested the testimony of certain witnesses, specifically Prosecutor A, adult child witness, be received in closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, the court is required to consider the countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and to maintain confidence in the judicial process. The court must also remain mindful of the constitutional rights of Mr. Robinson, as well as the statutory rights of Ms. Erica Kirk in her role as victim representative. And I also note that she filed today notice in regards to open and transparent courts. So I just want to touch on that. I acknowledge that filing as a victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, which was previously referred to as deputy county attorney in the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at this hearing. The defense asserts that the prosecutor's familial relationship with a witness creates a concurrent conflict of interest implicating Mr. Robinson's due process rights. The prosecutor's role, duties, and actions in this matter are therefore relevant to the issues before the court. If the prosecutor is called to testify, as it seems they will be, the court will consider the testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and in the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the prosecutor's testimony is not necessary and would not be narrowly tailored on the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and the defense to conduct the prosecutor's testimony in a closed session is respectfully denied. You may call your next witness, Mr. Burt.
Your Honor, I call Prosecutor A.
All right.
And I assume from the court's ruling, we do not need to do a closed session as to his identity.
We will not be doing a closed session as to his identity.
Thank you.
All right. Well, I'll go ahead and swear in the witness.
You solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Mr. Burt.
Thank you. Good afternoon, sir.
Good afternoon.
Could you tell us your name, please?
Chad Grunander.
And could you tell us what your business or occupation is?
I'm a prosecutor at the Utah County Attorney's Office.
How long have you been a prosecutor at the Utah County?
Almost 22 years.
Sir, in front of you, there's a number of exhibits, and they're marked, I believe, D through G. Do you see those there?
Yes, I do.
Okay. I'd like to go over those briefly, and then we'll proceed with your questioning. Do you recognize Exhibit D?
I do.
And could you tell the court what that is?
This is a biography that lists my name, my title at the Utah County Attorney's Office, with a brief description of what my duties are, my responsibilities, my education. It speaks to a little bit about my career and some of the cases that I've prosecuted over the years.
Your Honor, I'd move into evidence D, Exhibit D.
To the state? No objection. This exhibit is received and admitted into evidence.
Thank you. Next, Exhibit E. I wonder if you could identify that for the court.
Yes, this is an email that I sent to you as well as co-counsel for Mr. Robinson. It looks like I copied our prosecution team on this email as well. It was an email that was sent on the morning of October 1st, 2025, that disclosed an issue that came up with respect to this case that we felt was important enough to tell you, let the defense know.
Thank you.
This is my email.
I'd move E into evidence, Your Honor.
To the state. No objection. E is admitted into evidence and received.
And how about Exhibit F?
Yes, I see that. This is a photograph. It looks like it's a still shot from probably a TV screen from a Fox News alert that shows the amphitheater where Mr. Charlie Kirk was killed on September 10th.
And was this photograph used by you and an investigator to take some measurements out at the scene at some point?
It was, yes. In the middle of the photograph, you can see a dark bag. It's actually a dark blue bag that belonged to my daughter. She was at the scene on that day when Mr. Kirk was shot and killed. And I don't know if this was sent to me or I found it, but that just indicated where her bag was left behind when she left the scene. I used this along with an investigator to determine the approximate distance where she was standing when Mr. Kirk was shot and killed.
And what was that distance that you determined?
85 feet.
When did you make that measurement?
That measurement was done the day before, I believe, that I sent the email. So I believe that would have been September 30th of 2025.
Okay. Move that into evidence, Your Honor. Exhibit F.
The state? No objection. It is received and admitted into evidence. Thank you.
And Exhibit G.
Yes, I see that.
And could you tell the court what that is?
It looks like it's an email from Ms. Nestor, co-counsel for Mr. Robinson, that was sent to you as well as other attorneys, defense attorneys on Mr. Robinson's case. I became familiar with this document when you, Mr. Burt, sent this to me about 2 weeks ago or so. And that was the first time I recall seeing this and reading it. Some of it is redacted.
Right. Does that email, the unredacted portion, relate to a conversation that Ms. Nestler had with you on October 9th of 2025?
Yes, I can't say for sure it was October 9th, but we had a conversation on that day or right around that date over the phone, and Chris Ballard was also present with me. But yes, this reflects that conversation.
All right, and I move that into evidence, Your Honor.
As it relates to G.
Before determining if I object, I'd like to prepare a witness on the accuracy of this, the contents of this.
Let me ask if I could one more foundational question that could go to that.
Sure, we'll go to Mr. Burt and then to Mr. McBride. And so
Thank you.
It's not admitted into evidence just yet.
Did I send you that email for the purpose of you reviewing it and making sure it was accurate?
You did.
And did you have a response back to me as to whether or not it was accurate and how you would agree or disagree with the content?
I did. I don't know that it's word for word accurate, but the substance essentially is accurate. This is what we talked about and what was communicated.
All right. With that, I would renew the request to introduce G.
To Mr. McBride.
I will say, can I make one?
Counsel, just no questions been asked. I'm just waiting for Mr. McBride.
If I can provide a witness about the contents here.
You may.
Sure.
Did you write this email?
I did not write this email.
This was an email that was sent between defense counsel that memorialized your conversation with defense counsel. Is that right?
That's correct.
Okay. I want to ask you about some of the contents here. Chad is sure he talked with a few people in the office about his daughter's presence. Is that accurate?
Yes, that's accurate.
Does that give a time frame for when you talked to the people about your daughter's presence?
This does not give a time frame.
It obviously had to be before October 9th, right?
Correct.
He definitely shared it with the whole, and I'm quoting again, he definitely shared it with the whole prosecution team prior to notifying us. Is that accurate? Did you speak with every member of the prosecution team, meaning all the attorneys in your office, about your daughter's presence?
All of the attorneys assigned to this case?
Yes.
I believe so. I don't think I spoke to that each one individually, but they would have been present when it was talked about at some point, I'm sure.
Okay, let's see. Okay, I think that's all I have.
Thank you, Mr. McBride. And two, defense has renewed their motion to admit G into evidence to the state.
I don't object to the admission of G. The accuracy has been addressed by the witness. So,
all right. Exhibit G by defense is admitted into evidence. Mr.
Thank you.
Burt.
You want to make a clarifying comment?
I did. Right towards the end, before the redaction, it says his daughter has not been interviewed by any law enforcement. That was true at this time. I believe since then, she has been interviewed by law enforcement, my daughter.
Okay. So when that was written on the 9th, she had not been interviewed by law enforcement.
That is my understanding, yes. That's
And
correct.
When was she interviewed by law enforcement?
I believe it was after our last hearing in between January 16th and today.
And can you tell me what role, if any, you had in arranging that interview?
I didn't have any role in that. I was just informed that it was going to happen.
Okay, thank you. Now, I'd like to direct your attention to September 10th, 2025. Can you tell me where you were around noon of that day?
I was up in Davis County, in Layton, at a convention center. I was there with my boss, Jeff Gray. I was actually presenting to the elected county attorneys in the state of Utah at a conference.
And was anybody else from your office present at that conference?
No, just the two of us.
Did something happen in relation to your daughter while you were at the conference?
Yeah, shortly after I finished presenting, we were standing around. I was standing next to my boss and some of the other county attorneys in the state, and I started to receive some texts from my daughter that were sent to our group family text group.
And can you recall for me what the content of that initial text was?
Yes, there was a text that came in, I think at 12:25, I believe, that was in all caps, and it said someone was shot or someone got shot. There was another text that came in. I may have seen it at the same time, but it's the same timestamp that said something to the effect, I'm okay. Everyone's running inside. Okay.
And just to refresh your memory, we were recently provided with some of your daughter's emails and screenshots, one of which was a screenshot of a outgoing phone call to you at 12:28 p.m. Do you recall that?
I do. I believe I actually tried to call her, and I don't think she picked up, and then she called me.
All right. And according to the screenshot, that was a 1-minute call. Do you recall what you said, what was said during that conversation?
I think I was checking on her well-being to make sure she was okay. I don't know that we even talked too much about the facts, what occurred. It was a short phone call, but I wanted to make sure she was okay. That's why I called.
Sure. What was your initial reaction when you learned that she was present at what probably you didn't know much about at that point?
Well, I was startled. I was concerned for her welfare. I understood almost immediately when I found out about it that she was okay, that she was out of danger, but it was concerning.
Now, did you know that she was attending this event?
I did. She had talked about it in the days preceding that she was going to go to this rally.
And did you have some discussion with her about whether that was a good idea, bad idea, or you had no position on it?
No position. We didn't talk about that.
And what did you talk about in relation to Charlie Kirk? This is before September 10th.
Just that I had become aware, probably through her, that he was coming to UVU. She would watch Charlie Kirk from time to time online, and she was excited to go see him at this rally.
Okay, so 12:28, you have this phone call with her. And then do you recall you communicating back with her by way of text?
Yes, I remember asking her a question a few minutes later, asking whether she heard what sounded like a gunshot.
And is that the reference? I think it's attached to the opposition to the motion as Exhibit B, an entry at 12:35.
That sounds right.
Hannah, did you hear a gunshot or what sounded like a gunshot?
That's correct.
That was from you to her by way of text.
Yes.
And did you get a response back from her?
Yes, she responded, I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck, ... Not sure.
So at that point, did you share the email exchange or the text exchanges with anyone, either verbally or actually sending the text to anybody?
I know I spoke with Jeff Gray about these text messages. I may have even alerted him to the fact that there had been a shooting prior to even sending that text to my daughter, just because we were right there together. But we did talk about that briefly. Within a few minutes after receiving that last response, I know I called our office. I spoke with Chris Ballard to put him on notice that this had happened at UVU. I don't believe it had hit the media yet, news media anyway. And then shortly after that, I also called David Sturgill, another prosecutor in our office, to make him aware of it and to ask him to make himself available for questions and to assist law enforcement with any questions they might have while we, Mr. Gray and I, needed to travel down to Utah County.
And were you still at the location of the conference when you were making these calls?
I believe so, yes.
When did you actually leave to head to UVU?
Probably, I want to say I made that last phone call to Mr. Sturgill about 12:44. I think probably by 12:50 or so, I was probably on the road heading down to Utah County.
Do you recall, again, this is referencing Exhibit B to the opposition at 12:40, you sending a text to your daughter, quote, I'm getting live information, but I can't share it right now.
Yes, I remember. I think that was on the family group text.
Yes.
I think there was chatter on that group text from my sons. I think my wife as well. I think someone may have asked me, can you tell us anything or what's going on? And I just let them know I'm learning things, but I can't talk about it.
And when you say you were getting live information, who are you getting live information from? Do you recall?
Can you remind me of what time that text was?
That was 12:40 p.m. on the 10th.
I do not recall, counsel.
Okay.
I think I had just communicated with my daughter is all. I don't know if in those text exchange, I don't know if my kids were online and seeing something through social media that they were sharing with me. I'm not sure.
Okay. Before you left to head to UVU, did you speak to anybody else in your office?
I believe it was just Chris Ballard, David Sturgill. It's possible I may have spoken with a legal assistant of ours, maybe Haley Christensen, maybe Tammy Painter, but I don't specifically recall that.
And of those people you spoke with, who did you mention your daughter was present at the event?
I don't have a specific memory telling Chris or David about my daughter, but that's how I learned about it. So I'm confident that I shared with them that my daughter was present when this happened, and that's how I found out.
Did you drive by yourself to the UVU?
I drove down to Orem and parked my car near the In-N-Out in Barnes & Noble. Jeff Gray met me there. He came down, left probably 15, 20 minutes later after I did. We met there, and then the two of us drove from that location to UVU.
And what did you do there at the scene once you got there?
We tried to understand what was happening. It was quite chaotic. There were a number of local law enforcement agencies that were already there present. Federal law enforcement agencies were arriving. We were trying to connect the dots as far as what had happened, make ourselves available to answer questions, to assist in reviewing warrants, for example, which did happen later. It was just very busy, very chaotic.
Sure. How long did it take you to get from the conference to the scene?
Oh, probably took me approximately an hour to get down there, maybe less. I waited for Jeff for a few minutes, and it probably took us 10 minutes to get into the command scene.
During that time period, did you have any communication with anybody about where your daughter was at that time?
I don't believe so. I don't know that I knew precisely. I'm confident I didn't know precisely where my daughter was at that time. Just that she wasn't in harm's way, at least at that point.
But at that point, you didn't know whether she was still at the scene or had gone.
I knew she had left because when we talked, I believe she had made her way to the parking lot and was waiting for a friend to go home. So I knew she wasn't at the scene itself.
When you got there, your understanding why she was gone.
When I got to the campus?
Yes.
Yes, she was gone by then.
Okay. Did you have some communication from anybody about a piece of property of your daughter's being there at the crime scene?
Yes, she had informed me that she left her book bag behind in the amphitheater, which is the subject of Exhibit F, in part at least. And that was communicated later that day to law enforcement that her book bag was there. It had her laptop, books and notes and things in it.
You didn't see it there when you were at the scene?
I actually did at one point take a picture because I believe later in the day I spoke with my daughter. I asked for a description. I don't think I knew exactly what her bag looked like. And I think I was standing on the scene and through a window took a picture of what ended up being her bag, sent that to her, and she said, yeah, that's my bag.
And did you request anybody in law enforcement that you have permission to take that bag at that point because it belonged to your daughter?
I just let them know that that was my daughter's and that as soon as the scene was released, as soon as possible, if we could retrieve that bag.
Do you recall who in law enforcement you spoke to while you were at the scene at the UV?
I think I mentioned it once. She's with the State Bureau of Investigations. I should know her name, female, Polynesian. I know one of my co-counsel would remember her name. She helped process the scene.
All right. And did you mention to her or anybody else that your daughter was a potential witness at that point?
I'm sure I mentioned that my daughter was there and left a bag behind. I don't think I would have, I'm confident I didn't characterize it as she's a potential witness here.
Or say that she was there during the incident that happened.
I probably communicated that.
And that would have been to one or more law enforcement people.
Correct. And I know I was also speaking with David Sturgill in my office about it because he was on the scene. I was back and forth to the office in the command scene at UVU over the next couple of days. And so I spoke with him about it as well.
Okay. And did, to your knowledge, anybody request to interview your daughter around the time of the 10th?
No, not to my knowledge.
How long did you stay at the scene that day?
I was at the scene. I don't believe I left to go back to the office that first day. We were probably there until 9 or 10 o'clock into the evening, maybe even 11 o'clock later into the day.
Now, at that point, you were the chief deputy in the office, correct?
Correct.
What were your responsibilities in terms of charging?
In terms of charging this case?
Yes.
I was part of the effort in deciding what charges were appropriate here. In our office, we have a policy that the county attorney, Jeff Gray, any homicide case, he has to approve the charges. So I talked with Mr. Gray about the facts of this case as we understood them as they were coming in over the next few days. I'm sure I consulted with Ryan McBride, David Sturgill. They spent the better part of 2 days on scene, helping law enforcement. Chris Ballard, I would have talked to Chris about that. It would have been a team effort in large part, but the ultimate approval was Mr. Gray's.
You oversee the major crimes and general crimes divisions, correct?
I do.
And major crimes in your office includes homicides, I assume.
We don't have a homicide unit, but we have a special victims unit for sex crimes, and then we have a violent crimes unit. Most of our homicides are prosecuted by our violent crimes unit, but they're also specifically assigned given where the case gets, what court it gets assigned to, and the skill set of those attorneys and experience, et cetera.
Okay. Now, because of your connection in the case, did you become aware that on the morning of the 12th, early morning, that Mr. Robinson was arrested?
Yes,
About 4 o'clock in the morning?
I became aware of that, yes.
Okay. And are you aware that at 7:18 a.m. on the 12th, a affidavit of probable cause was filed by a state investigator by the name of Brian Davis?
I would have become aware at some point of that. I don't know exactly when, but I would have known that upon his arrest and booking, there would have been an affidavit attached.
And what role did you play, if any, in drafting that declaration, or at least overseeing it?
I was not involved in that. I didn't oversee that.
What was your role at that point in terms of overseeing what was going to happen to Mr. Robinson?
In large part, making sure that we had attorneys that were on scene at the command center available to assist law enforcement, communicate with Jeff Gray what we were learning about the case, trying to get the best understanding we could as far as what was happening, what the facts were, in anticipation of having to bring charges within the next few days. So as far as making assignments, I was probably speaking with Mr. McBride, Mr. Sturgill about their involvement, and just generally trying to learn about the case.
Were you aware of the media attention that was being devoted to this case early on before an arrest of Mr. Robinson?
Yes, I was aware there was a lot of media involved. I remember going home the first night and it was all over the news media.
And were you aware that by September 11th and before the arrest of Mr. Robinson, that the governor of the state was announcing that the death penalty would be sought in this case?
I recall hearing that the governor had talked about the death penalty. I don't remember him saying it would be sought, but I remember him saying something to the effect that we still have the death penalty in the state of Utah.
What is your, I'm sorry.
Something to that effect.
What is your understanding of when the decision was made to seek the death penalty in this case? The date and time, if you know.
I wouldn't know the time, but I do recall early on, probably the second or third day, there was discussion that if we have the facts to support it, that Jeff was confident that he would be probably seeking the death penalty. I don't know if he had made a hard decision on that on the second or third day, but he was definitely considering it.
When you say the second or third day, are you talking about the second or third day in relation to when the incident happened on the 10th?
It would have been after, well, it would have been probably the 12th or 13th.
Okay.
It was following his arrest, I believe.
You're aware, are you not, that on the 13th, your office issued a press release, which included your name, indicating that we, the office, anticipated filing an information by the 16th.
I remember discussion about that press release. I don't remember the specifics of what was in the release, but that sounds right, because upon someone's booking, we have a certain amount of time in which we need to have an information filed, unless we seek an extension, and that would have been the 16th.
And so on the 13th, when that press release was released, had the decision already been made to seek the death penalty in the case?
I don't know, counsel. I don't have. So the 13th, this happened on the 10th. So the 13th, that was a Wednesday. It may have been made on that day, but I'm not entirely sure.
Or it could have been made before that day. True.
I suppose, but that would have to be a question for Jeff Gray to know for sure.
Well, as a chief deputy in the office, is that a decision that you normally would have been part of the process in deciding?
Oftentimes, yes, and I'm sure that Jeff ran it by me, but by the time we were talking about the death penalty, my role was, do we have the facts to support an aggravating factor under Utah law that would support a potential death penalty case? But I don't remember a conversation with Jeff Gray where he asked, what would you do in this situation? But there would have been discussions, I'm sure.
Who in your office at that time, around September 10th, had more experience than you in prosecuting homicide cases?
Maybe Tim Taylor, who's now in our civil division. That might be it.
Within the criminal?
Within the criminal division, probably no one.
And had your role in prior cases been such that you were consulted on the decision of whether to seek death or not?
In this case, was I consulted?
Now,
or in other
let me
cases?
rephrase it. My apologies. In other cases that you have been involved as the lead prosecutor, was it routine for Mr. Gray to seek your advice as to whether to seek death or not in a case that you were primarily in charge of?
Yes.
And can you give me an example of where that had happened?
The prosecution.
Objection, relevance.
Counsel, could you repeat the question that you asked? I want to
Sure.
make sure I'm ruling on this.
The question is, can you give me, you had said there have been cases where he's consulted you on whether to seek death or not. I asked you whether you could give me an example of such a case. And that was the objection.
All right. And as to relevance, Mr. McBride, I'll hear your argument.
Yeah, what his role has been in the past and talking about, he's already testified, he has had a role in those discussions in the past. Now we're asking what specific instances he has had involvement. I mean, I don't know, we're going to get into the facts of these cases. We need to bring this back to the question, which is, what role did his daughter's presence at the event have on the decision-making in this case? That's what we need to get to. And I don't think how it's happened in other cases is relevant here. We move along, got 45 minutes until this hearing ends.
Thank you, Mr. McBride. Mr. Burt.
You know, I think Mr. Gray referenced in his opposition, his statement that the reason he was seeking the death penalty in this case was because of what happened in the Janes case. And I believe that this witness was the lead prosecutor in that case, was consulted about the death penalty, so it relates directly to what Mr. Gray testified about.
I will overrule the objection, but counsel, we're not going to go far down that path.
I understand.
Thank you.
Go ahead.
Yes, Michael Jane is a current prosecution. It's an aggravated murder case that I'm currently the lead prosecutor on.
All right. And generally in your office, is Mr. Gray typically involved in hands-on litigating a case as opposed to being the administrator in the office?
No, not typically.
Okay. And in cases where he's obviously the county attorney, but you're prosecuting a case, it's typical for him to seek your advice on whether to seek or not seek death, correct?
Sure.
Okay.
That's fair.
Now, on September 16th, your office filed a notice of intent to seek the death penalty, correct?
Yes, I believe it was Jeff Gray that actually prepared that notice and caused it to be filed.
And what discussion, if any, did Mr. Gray have with your team regarding whether that notice should be filed at that time?
I remember Jeff expressing to us that the decision was made. He'd made the decision that he was going to announce the death penalty, seek the death penalty in this case. He wanted to do it earlier rather than later and decided to do it at the same time we charged the case. And so I don't know if it was filed. I think it was filed a few minutes or so after the information was filed, but it was filed prior to Mr. Robinson's first appearance, which occurred later that afternoon on the 16th.
In the opposition to our motion, Mr. Gray indicates in reference to the Jane case, quoting here, the county attorney concluded from the outset that he would seek the death penalty, but choosing to follow the convention of some, the county attorney initially opted to wait until after the prelim. Do you know what he was referencing when he referred to the convention of some in terms of what the practice was?
The statute calls for, I think it's within 60 days after arraignment, which takes place after a preliminary hearing, is when the notice of intent to seek death needs to be filed. Many prosecutors wait until after a preliminary hearing to file that notice. In Michael Jane, we didn't, but it was a handful of months or so after the information was filed before the notice of intent to seek death was filed. So I think the majority of cases, that notice of intent to seek death is probably filed after the prelim.
And do you know the reason for that policy, for that practice?
Probably, well, I can give you my input. I mean, I think you may have a better understanding as far as the strength of the case, where it's headed. There may have been plea negotiations that occurred in between that time. So could be for a few reasons.
Also, you might know a little bit more about the defendant's background by that point. I assume.
Sure. On the mitigation or aggravation investigation, sure.
Have you ever had a case in your office where a decision was made to seek the death penalty solely on the basis of the facts of the crime without regard to the defendant's background?
I'm not aware of that.
Now, let me ask you a couple of questions about Exhibit E, and then we're almost done here. Exhibit E is your email to the defense in which you state, "We don't believe the following creates a conflict for me and Tyler Robinson's case, but it's something that should be disclosed to you, his attorneys. And then you outline basically what we've been discussing here today, correct?
Correct.
And can you tell me how that decision was reached to send this email to the defense, what the considerations were?
Sure. The considerations were that I would be part of the prosecution team. I would be assigned to this case to help lead this team. And my daughter was present. And there's an argument that can be made with respect to a conflict. And so our practice, my practice, is to, if there's an argument, disclose it. We're not in the business of hiding anything. And so we knew from the outset that once counsel was appointed, that we would be disclosing this to the defense, and they would respond accordingly, however they thought they should.
Reference has been made to these Utah prosecutors' best practices, Exhibit I. You're familiar with those?
Exhibit I, not specifically, but.
Let me show you that. Did I approach you on it?
Yes. It's
You are
20,
good.
it's 29 pages long, so you'll have to refer me
I'm
to.
not going to ask you to read the whole thing, but you're generally familiar with that, right?
From time to time.
And there's a statement in there, I'll read it to you, which says if there's close cases should be resolved in favor of disclosure in a situation where there might be a potential conflict.
Sure, I would agree with that.
And did that motivate your behavior here in terms of why you disclosed what you did in that email?
As far as it being close, is that the question?
Well, did that motivate your behavior in disclosing it?
What motivated my behavior was to just act with professionalism and integrity. Disclose this to the defense. But don't mistake our disclosure, my disclosure, our abundance of caution, our professionalism, integrity to be a concession that we believe there's merit to this alleged conflict.
Sure. And you realized in disclosing that the ultimate decision is really the courts, right?
Correct.
All right. And there's a section of those guidelines that says if a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal. Did you take into account that standard when you were making decisions about what to disclose and what the significance of the fact was that your daughter was present at the scene?
Sure, we considered the appearance of conflict here, but when we learned and had a good grasp of what her experience was, or perhaps most importantly, what her experience wasn't, what she didn't see, we felt confident that there's just simply no conflict here. And once people become aware of the facts, there's no appearance of conflict.
Now, you had made that disclosure to us on October 1st, correct?
Correct.
When had you conducted the investigation about the measurements?
The day before.
The day before.
Mhm.
And do you know when Mr. Gray conducted the subsequent investigation into whether you could see her position from where the alleged shooter was?
That was much later.
So that part of the investigation had not been done at the time you decided there was no conflict.
That's correct.
And similarly, no one in law enforcement had interviewed your daughter, independent of you and what we see in the text, prior to you deciding that there was no conflict here, correct?
Yes.
Lastly, I wanted to ask you about the email from Ms. Nestor that summarized the conversation you had with her, because you said there was maybe some clarification needed there. She said in the email, Chad is sure he talked with a few people in the office about his daughter's presence. When did those conversations take place?
It would have started almost immediately after receiving her text. I spoke with Jeff Gray about that. He was made aware of her presence. Within minutes after I made a phone call to Chris Ballard and then David Sturgill, I'm confident that I mentioned to them that she was present.
And that email then goes on to say he definitely shared it with the whole prosecution team prior to notifying us. Is that correct?
Yes, I believe so. I think we talked about this issue, and it was decided as a team that, yeah, no question, we're going to disclose this. So I'm sure it came up.
And was that in one meeting? Was it in several meetings? Was it discussing it with each team member individually? Or give me a better sense of that.
I don't know that I spoke with every team member individually, some of them for sure. Mr. Gray, Chris Ballard. I'm sure I had conversations with Ryan McBride and David Sturgill as well. I don't know about Lauren Hunt. Lauren is on this case as well, other than outside of a team setting. So there would have been discussions as a team and then also individual discussions.
I see. Could I have one moment, Judge? I think I'm done.
Of course. The state.
Will you please describe the effect when you learned that your daughter had been present on September 10th? Over the next maybe 8 hours, you drive down to Utah County, you drive to Utah Valley University. What effect, and you're interacting with law enforcement, what effect did your daughter's presence have on the discussions you're having with law enforcement, your work as a prosecutor at that point?
Other than informing the investigator, I can't recall her name right now, about her book bag being present, putting law enforcement on notice that needed to be retrieved once the scene was released. It was busy. We were trying to learn about the case, the facts of the case. I don't know that I talked much, if anything, about my daughter's presence there. The effect it had on me, I mean, obviously concerned when I first heard and saw these text messages. That's why I called her to make sure she was okay. She was out. She wasn't in danger any longer. And then there was work to be done. And so we got busy trying to understand what had happened that day and start to put the pieces together. I'm sure I reflected on it from time to time, but I don't specifically recall.
Okay. Did it affect any decisions you made as to what you're doing as an attorney out at the scene?
No, absolutely no effect.
As far as the charging decisions, there's been some discussion or testimony about how the charging decisions were made in this case. Did your daughter's presence have any influence on the charging decision that was made in this case?
No, none at all. What was important was, did we have the facts, substantial evidence to support an aggravating factor? And look at the case law. And there's the Johnson case, the Pierre case, the Sosa Hurtado case. I was researching those cases, considering the zone of danger, if you will, which is talked about, I think, in the Johnson case. And it was clear that my daughter was not within the zone of danger. It had no effect.
Okay. Did it have any effect on the death penalty decision? your daughter's presence?
Not from my perspective, and I don't believe it had any effect on Mr. Gray's perspective.
Was your daughter's presence discussed as that decision was being made?
No.
Has it had any effect on the decisions that have been made in the prosecution of this case since?
No.
Now, as a father, have you monitored your daughter's condition?
Sure. Her emotional condition?
Yes.
How well of course.
And what's your understanding? How has her presence affected her? Has she had to get therapy?
No, she has not.
Has she had to miss work or school?
No.
Have you noticed a change in her demeanor or behavior at home?
No.
Just a moment, if I may. Your conversation with her. Once again, you were asked, or one of the statements in there is that you talked to the whole prosecution team about your daughter's presence. What do you mean you talked about your daughter's presence? Just that she was there, or what? And I want to ask you this question outside of the current motion to disqualify, because I know that this motion to disqualify has brought her presence into center focus. But outside of this motion to disqualify, what did you mean you told others or you talked to others about her presence?
Well, I had informed them that my daughter was there when Charlie Kirk was shot and killed. She was at the rally. And I'm sure we talked about what her experience amounted to based upon the text messages that I had received. I know we talked about my disclosure, the disclosure email. In there, I talk about her emotional state. So I probably shared with them that she seems to be doing fine, that she hasn't needed to speak with a professional about it.
Did you learn anything from your daughter's presence that you hadn't learned from other evidence in this case?
No.
For example, that Charlie Kirk had been shot and killed.
That's correct.
Did you learn that from your daughter's presence, or did you learn that from other evidence in the case?
Well, both, because she informed me that it looked like Charlie was shot. So I would have initially heard that from her. But there is other evidence, yes, direct evidence.
Would her testimony be admissible in trial?
I don't believe so.
That Charlie Kirk was shot and killed?
I think that calls for a legal opinion.
Counsel,
It's probably true.
I'll sustain the objection.
Let me make sure I've just asked that question adequately. Was there any information you gained from your daughter that you did not gain from other evidence that was collected in this case?
No.
Thank you. Nothing else.
Thank you, Mr. McBride. May this witness be excused. Oh, I'm sorry, Mr. Burt. Thank you.
You mentioned that the decision to seek death was based on the assessment of whether the aggravating factor was present or not, correct?
Correct.
And the aggravating factor is creation of danger to other people in the zone of danger.
Was another put at great risk of death?
Is the way the statute reads.
Correct.
At the time that decision was made, had you done any investigation yourself on who was or was not in the zone of danger?
We, I believe, as early as the second day, and I'm referring to, I think, the 11th, walked the scene as soon as law enforcement released the scene. And I positioned myself up on the shooter's perch, if you will, And at that time, I knew based upon the photographs of where my daughter was. And given where the shooter was and shot and killed Mr. Kirk, yes, I would have known that she was not within the zone of danger
And nor
by
was
the second day.
And the measurements you took in that regard took place when? End of September?
End of September.
Okay.
That's correct.
And that was the first measuring that you were involved with or that you were aware of?
Yes.
Thank you. That's all I have.
All right.
Your Honor, I do have follow-up on that.
All right, Mr. McBride.
I want to ask you a little bit more about that zone of danger. Were you aware of other evidence that there are other people in the zone of danger?
Yes, absolutely.
What kind of evidence?
There was a substantial amount of social media evidence that was coming in, videos of the actual assassination of Charlie Kirk. There was the questioner that stood in front of him asking the question when he was shot and killed. There were others near him. There were people to the left and to the right of Mr. Kirk, people right behind Mr. Kirk as well, several individuals.
And that testimony and that evidence, does that come from your daughter?
No.
Comes from other people who recorded the incident. Is that right?
Correct.
Same question. That's probably all we have for redirect. Thank you. Nothing else.
Thank you, Mr. McBride. Anything further for this witness?
No, Your Honor.
May this witness be excused.
Yes.
Thank you, Mr. Grenadier. To defense.
Your Honor, at this time, we don't intend to call any more witnesses and we would submit on our motion. I do believe the state may have a witness or two.
All right, turning to the state. Standing right by the lectern, you'll be sworn in.
You solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth.
All right, Sierra, if you wouldn't mind having a seat right there, adjust the microphone. There should be a bottle of water if you get thirsty or dry. And just bring that microphone a little bit closer just so that the record picks you up. All right, Mr. McBride.
Before we turn to Sergeant Hull, the state has submitted an affidavit from Agent Cole Christensen. I've just conferred with counsel. I think we're both on board that the court can consider that in reaching its conclusion on this matter today. Save us having to call him as a witness.
All right, what was the proposed exhibit number for that?
It's an attachment to the state's pleading, addendum C.
And so how is it going to be marked? Just for record keeping for this hearing?
Let's call it State's Exhibit 13. Pardon marking that.
All right, the state is moving that into evidence to defense. Any objection?
Your Honor, I think it's already been submitted and attached to the motion, so no objection.
All right, State's Exhibit 13 is received into evidence in this case.
Will you please state your name?
Agent Dave Hull.
And what is your position?
I'm an investigative agent with the State Bureau of Investigations.
What is your role?
Your Honor, could you ask him to move that microphone a little closer? I'm having trouble hearing Agent Hull.
You need to bring the microphone almost to the point is where it's uncomfortable to you. So bring it forward. And we just want to make sure the record picks you up.
Okay, is that better?
Yes, thank you.
I want to ask you about some of the evidence collected in this case. Are you aware generally of the evidence that has been collected in this case and the investigation that has been done?
I am, yes.
First off, will you describe basically the scene where Charlie Kirk was killed when he was shot and killed?
Yeah, the scene is essentially an amphitheater setup. Mr. Kirk's stage was set up at the base of the amphitheater. And then there are, I guess, semicircular tiers that move back up and away from the stage area, creating the amphitheater.
And how many people approximately were present?
Estimates for attendance at the event itself were about 3,000 people, and then the campus was open to regular students that day also.
How did the State Bureau of Investigation determine who to interview of those 3,000 people?
There were several processes used. There was a general request for information that was put out for people who attended the event. There was a time when people who had attended the event returned to collect personal belongings, and posters and requests were made for people to provide information. People who had volunteered information. So several different sources and several different ways that we made contact with the public.
Okay. And did all of the witnesses, or were all of the witnesses of equal value, those that were present at the event?
Essentially, yes. There were one or two who were able to provide different information, but essentially the majority of people who provided information provided confirming or repetitive information about their experience.
Okay. I want to ask you about videos that were collected. Well, first, do you have an approximate number of how many witnesses were interviewed out of those that were present at the event?
I know that as a state entity, we're able to obtain over 40, what we would call an 1102 or a witness statement, which is a written statement. I also know that the FBI provided us with a number of written statements and interviews that they conducted also.
So did you say 40?
At least 40, it would be more than that.
Okay. Plus FBI collected additional statements.
Correct.
Okay. Did you collect videos that some of these people had taken?
We did, yes.
I would like to present State's Exhibit 1. You should see it appear on your screen in a moment. Okay, if you can just pause that for a moment, Kimberly, thank you. Do you recognize State's Exhibit 1?
I do, yes.
What is that?
That was a video provided by an individual named Mr. Lyman, who was behind where the stage was set up. There's a kind of a walkway that goes under a building. And then behind that, there were vehicles staged, and that's when Mr. Kirk arrived on the scene.
For the purposes of this hearing, I'd move the admission of Exhibit 1.
No objection.
It's received and admitted. Thank you.
Please play that video. Okay, will you describe where this is we're seeing, or what we're seeing and where this video is capturing at this point? And we are at 14 seconds into the video.
That's Mr. Kirk's arrival to the event. As I mentioned before, that kind of concrete breezeway that was behind the stage area. Mr. Kirk made his way through that. And then he would have been stage right when he first entered into the amphitheater. I didn't know at the time, but I guess he has a tradition of throwing out hats to the audience, and so that was what he commenced doing at that time.
Okay, and then in a minute, we're going to see the video capture the actual amphitheater area. Is that accurate?
I believe so, yes.
Okay, go ahead and hit play, please. Thank you. Are there other videos that the Bureau of Investigation collected that capture the crowd in the event?
Yes, there are numerous videos that were collected from individuals who had been attendees at the event, and also videos from the university itself.
Meaning Utah Valley University surveillance footage?
Correct, yes. Utah Valley University has a comprehensive surveillance system.
And Turning Point USA, Charlie Kirk's organization, did they also capture videos of the event?
They did, yes.
I'd like to show you State's Exhibit number 2. I have in front of you State's Exhibit number 2. Do you recognize that?
I do, yes.
And is that a video that's collected in the investigation in this case?
It is, yes.
For the purpose of the limited purpose of this hearing, I'd move the admission of Plaintiff's Exhibit 2.
No objection.
It's admitted. Thank you.
Okay. Will you describe what we're going to see here before we hit the play button?
Yeah, this video will actually zoom into the roof area of the buildings. You can see center screen. In doing so, the video will capture an individual on the corner of the rooftop.
Was this video captured by the person we're referring to as Prosecutor A's daughter?
No.
Okay. Please press play.
You think he'd already be in place? You would think that. So there's somebody on the roof right there? Just saying? He just ran from over, where's my finger? Whoa. From over there, ran in. And now he's right there. Just saying.
Now, that roof that was recorded in that video, first, is there other surveillance of that person a person in that location at that time running to that spot?
There is additional footage, yes.
Where does that come from?
That came from the Utah Valley University security cameras.
All right. Is there another individual that also recorded a person running after the shooting from the roof?
Not to my recollection, no.
Any video from someone, do you recall a video from someone in the Hall of Flags who may have recorded someone running after the shooting?
Yes, there was an individual who recorded from the Hall of Flags. It's an interior video looking through the windows, but I believe an individual is visible on the rooftop also in that video.
Okay, thank you. As far as other witnesses, some of the other relevant witnesses in this case, who is Hunter Kozak?
My recollection is he was the individual who was asking the question to Mr. Kirk at the time that he was shot.
Okay. Would he be a witness in this case? Could he be a witness, I should ask?
Potentially, yes.
Okay. Where was he positioned in relation to Mr. Kirk?
I believe the way the stage was set up, he was approximately the same height level of Mr. Kirk, but he would have been directly in front of him where they had the barriers set up separating the crowd from the stage area.
Okay. I would like to show you Exhibit 4. Now, Exhibit 4, this is a screen capture from a video. Do you recognize Exhibit 4?
I do, yes.
You remember the video from which this is taken?
Yeah, it was a cell phone video belonging to an attendee of the event.
And that attendee was not the prosecutor's child.
It was not the prosecutor's child, no.
Will you describe what the video shows?
If I recall, this is a graphic video that does actually show the time that Mr. Kirk is impacted by a projectile and the subsequent trauma and reaction of the crowd.
Okay. Does it show the position of the people to his right and to his left?
Mr. Kirk's right and left?
Yes.
In a limited manner, it does, yes.
Okay. Does it show the position, the video, we're speaking of the video, does the video show the position of the questioner, Mr. Kozak?
I don't recall if it pans all the way to the question asker or not specifically, but there is potential that it does, yes.
I'd move the admission of Plaintiff's Exhibit 4.
No objection.
It is admitted into evidence.
Did you interview mothers with children that were at the event?
I believe there were some mothers who had children at the event who provided witness statements to the State Bureau, yes.
Okay. I'd like to show you Plaintiff's Exhibit number 5. Do you recognize Exhibit 5?
I do, yes.
And this, my understanding is this is also a screenshot from a video from Turning Point USA. Is that accurate?
Yes, this was a video taken by Turning Point USA.
Does this show the questioner, Mr. Hunter Kozak, in front of Charlie Kirk?
It does. You can see him holding the microphone just above Mr. Kirk's head.
Okay. And the video, will you describe what the video shows?
From my recollection, this video also shows the point that Mr. Kirk is struck by a projectile, and it shows the reaction of the individual asking the question, along with the reaction of Mr. Kirk's security detail and those others in the crowd.
Okay. I also see another, I'll leave it at that. From what you have gathered in the investigation, were you able to determine the direction from which the bullet came?
Yes.
And in this Exhibit 5, where would that direction have been?
Essentially from straight in front of Mr. Kirk.
Okay. And which side of Mr. Kirk's body did the bullet strike him?
It would have been his left.
All right. All right, and finally, Exhibit number 3. Oh, I moved the admission of Exhibit number 5.
No objection.
It's admitted.
I have Exhibit number 3 up in front of you. Do you recognize that?
Yes, that's a university or a Utah Valley University video of the kind of the breezeway area that I previously described.
And Exhibit number 3 is a screenshot from that video. Is that right?
Yes, that's correct.
And will you describe what plaintiff's exhibit, well, the video itself actually shows?
Yes. If we were to play this video, this shows also the time that Mr. Kirk was impacted by the projectile. And it shows the activity that occurs behind the stage area and the movement of people prior to, during, and then after the incident. On both sides of the breezeway where the barriers are, the crowd actually break through the barrier in an effort to escape the area.
Does this video show others that may have been exposed to risk if that bullet would have missed Mr. Kirk?
I believe so, yes.
When you responded on September 10th, did you know who Chad Grunander was?
I did not, no.
Did you know anything about his daughter?
I did not.
Did you eventually learn that a prosecutor's daughter was on the scene?
I did.
When did you learn that?
I believe when I found out, it was when the motion had been filed for the conflict argument.
Okay, so prior to that, did the presence of that person, that individual, have any bearing at all in your investigation in the case?
No, I was not aware of her presence at the event.
You have read that adult child's affidavit in preparation for this hearing, right?
Correct, yes.
And was there anything in that affidavit that changed your view of the case or the investigation you should do?
There was not, no.
Was there anything new in the affidavit?
No.
You're here for her testimony today, correct?
Correct, I was.
Same questions. Anything new in that testimony?
No additional information.
Now, I want to ask you a little bit about the value of the witnesses as it relates to this case. Did the witnesses on scene identify the shooter?
No, we did not have a witness that identified the shooter on scene.
What was the the primary goal of your investigation, to identify the shooter?
It was, yes.
And I want to ask you about the existence of other evidence. You said you collected surveillance evidence from Utah Valley University. Is that right?
That's correct.
Did that give you some additional information on identifying the shooter?
It did, yes.
How about doorbell cameras for the areas around Utah Valley University?
Yes, we collected a large number of doorbell camera footage from multiple residences in the area. not just in Orem, but also in St. George. And we also recovered video footage from multiple businesses in the area of the university campus in Orem, and also from businesses between Orem and St. George. So there's a large amount of video footage obtained.
And did those help you identify the shooter?
They did, yes.
Text messages, did you collect text messages from associates of Tyler Robinson?
We did, yes.
And did those, did those have any evidentiary value?
They did, yes.
How so?
Some of the communications between Mr. Robinson and people that he knew indicated that he had been involved in the incident at Utah Valley University.
Okay, and you say that indicated he'd been involved. What do you mean by that?
There was, I don't recall specifically with text messages, but some of the social media chats, there were admissions that he had been involved in the incident as the shooter.
Okay. CSI evidence. Was CSI evidence, crime scene investigation, collected in this case?
It was, yes.
Was DNA evidence collected?
It was, yes.
Does that evidence help you identify the shooter?
It does, yeah. The evidence that was obtained did provide us with DNA evidence in relation to items used during the commission of the crime, and then they were compared to Mr. Robinson.
Okay, items used meaning what?
Specifically, a screwdriver that was recovered on the rooftop of one of the buildings, and a firearm that was recovered in a tree area on campus.
And you didn't do the DNA testing yourself, correct?
I did not know.
But you're aware there have been reports that have given evidence as to the identity of DNA on that rifle.
That's correct, yes.
Was a search warrant on the defendant's house executed in this case?
It was, yes, down in St. George.
And was evidence obtained from his house?
It was, yes.
What kind of evidence?
Kind of putting me on the spot, but if I recall, there were some bullet casings that had some inscriptions on. There were some tools that were believed to have been used to make those inscriptions. There were targets, I believe, that had been used, and also targets that had been purchased recently or just prior to the event. There was ring doorbell camera footage obtained from other residences down there. And then a number of electrical items, laptops and such that were collected as part of the warrant.
You said inscriptions on some shell casings found in his apartment. What value do those have?
That was relevant because the shell casings recovered with the firearm also had inscriptions on them.
You said there was evidence, the DNA, was evidence consistent or DNA consistent with the defendant's DNA found on that rifle?
Object to hearsay.
Counsel?
This really ought to be considered under kind of a 104 rule of evidence here. We're not offering the admission of this to prove guilt, but whether or not there's a conflict of interest, the existence of other evidence besides the adult child in this case is relevant to whether or not she is a material witness. If we've got DNA proving or suggesting or proving otherwise, it's directly relevant to that. And under 104, the court can consider it.
All right. Ms. Nestor, anything further?
No, sir.
All right. Based off, so I will overrule the objection based off Rule 104, and as it relates only to this case, this hearing today.
Understood.
Sorry, could you repeat the question?
Is DNA consistent with the defendant's DNA found on the firearm that was found at the scene?
Yes, the DNA on the firearm was consistent with that of Mr. Robinson.
You said the etchings, there was etchings in that firearm, and that there's also etchings in rounds in the firearm. Is that what I understand?
Yes, I believe the chambered round and other rounds found at the time had etchings upon them.
And you said there are rounds with etchings also found on them in the defendant's apartment. Is that right?
That's correct, yes.
Okay. That firearm, where was that found?
It was found in a wooded area just off of Campus Drive, wrapped in a black towel.
Okay. how critical are eyewitness statements of those present to the event to identifying the shooter?
They did not provide any information that allowed us to identify the shooter.
Okay. Okay, just a moment. I move the admission of State's Exhibit 3.
No objection.
It's admitted. Thank you.
Okay, nothing else.
All right. Council, I'll give you 6 minutes for redirect.
Woo, I'll talk fast, Your Honor.
All right.
And I'll run up to the front. Good afternoon. My name is Kathy Nestor. I represent Mr. Robinson, Agent Hall. You certainly seem familiar with a lot of the evidence here. Is it fair to say you're one of the key case agents in this matter?
That's correct.
All right. And as one of the case agents in this matter, certainly it's up to you to look at every piece of evidence that could be important in this case. Is that right?
That's correct.
And as a matter of fact, if I understood your testimony correctly, you said that you guys put posters up asking students, if you have videos, please give them to us. Is that right?
I believe that the posters were asking if anybody wanted to provide a statement to us, that they would be encouraged to do so.
So you encouraged all the kids that were there and other people to come forward and give you a statement. Did you not?
I did not personally know.
Your posters did.
The posters did, correct.
Okay. And you also put out a request for videos, if anybody had videos to present them to you. Did you not?
We asked if anybody had any information that would help us with our investigation, if they'd be willing to provide it to us. That's correct.
And it doesn't sound like you screened it. You were so like, if you have it, bring it to us, right?
I'm not sure what the question is.
You didn't screen for, well, we'll take your evidence, but we're not interested in your evidence. You took any evidence that came at you, right?
I guess the answer would be yes, because I can't screen it until I have it.
Exactly.
Okay.
Is there anybody that came forward and you said, yeah, we're really not interested in talking to you at all? We're not even going to take your statement?
I believe there were people who were pre-screened who wanted to provide information that didn't have any substantiated connection to the investigation.
But somebody connected with this investigation, spoke to them and decided they didn't have any valuable information, correct?
Yeah, they documented their contact and then made that decision.
Okay. And the videos that you got, you understand that these videos have been used far and wide to look to see if there were potentially other shooters in the crowd. Have you seen this on social media? Thousands of them?
Again, I guess I don't know what the question is.
All right. Are you aware that the videos that have been taken from the scene have been analyzed by people on social media and in the press to see if there was somebody else that could have been involved in this? Are you aware of that?
I'm aware that everybody has a theory on the case. Yes.
Everybody has a theory on it, right?
Mm-hmm.
So wouldn't you think it would be fair to say that any video that was taken there that could one way or another address whether those theories are good or bad, or whether your theory is good or bad, you guys should at least take a look at them? Fair?
Yes.
All right. And you became aware that Mr. Grunander had a child that was present at the scene. Is that right?
That's correct.
And did you look at her videos?
I did, yes.
When did you look at her videos?
When I received them, when she was interviewed by Agent Mortensen.
So that would have been a couple weeks ago.
Correct.
All right. But when you were doing your investigation of this case initially, you never looked at her videos.
Ms. Grunander did not come forward as a witness, no.
And the Utah County Attorney's Office knew that she had been there, right?
I'm sorry?
The Utah County Attorney's Office knew she had been there that day?
At the event?
Yes.
Correct.
And they knew she had videos?
I don't know if they knew she had videos or not, but they knew she'd been at the event.
But they sure weren't forwarded to you, were they?
Not until last week, no.
Okay. When this came out and there was a motion filed in court?
Correct.
All right. And have you ever interviewed Mr. Grunander's adult child?
As I said, Agent Mortensen did that interview. I did not.
And that was done when?
Either a week or 10 days ago.
Right. And so up until about 10 days ago, you all did not look at her videos, right?
No.
You did not interview her.
No.
And the county attorneys knew that she had been there, right?
Correct.
And they knew she had videos.
Correct.
And were you told by anyone not to interview her?
No, I was
Were
not.
you told by anyone to leave her alone?
I was not.
You said the SBI collected over 40 statements, is that right?
Correct.
And that's from people that were just in the audience?
The 40 that I mentioned is from people who were at the event, yes.
So people in the exact same situation that the prosecutor's daughter was in?
In terms of being at the event?
Yes.
Yes, people who were at the event.
And you thought they were worthy of taking statements from, right?
They came forward to give us statements, correct?
Because everybody's perspective is important.
If they're willing to share it, yes.
And as a matter of fact, you've gathered, as I understand it from today, I want to say around 300 terabytes of video information from the scene. Is that right?
I believe there's in the region of 248 terabytes of data from Utah Valley University alone.
And the adult child of Mr. Grunander is in the exact same position as everybody else who's given evidence in this case, isn't she?
In terms of being an attendee at the event?
Right?
Yes, she was an attendee at
And
the
having
event.
video
Yes.
and having witnessed things herself?
You would have to refer to her testimony as to what she witnessed.
Okay. And you mentioned, I know I have 2 minutes. I'm going to talk very fast. I know she's about to kill me. You mentioned the DNA evidence. You're certainly not a DNA expert. Is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
I'm not a DNA expert, so
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA.
I'm not aware of that, no.
Okay. And you're certain but I think I'm done. Thank you.
Thank you. All right, that concludes the taking of evidence, this portion of the hearing. We'll turn to closing arguments or arguments by the parties as it relates to this. May this witness step down.
Yes.
As much as he'd like to sit there indefinitely. We'll go ahead and excuse him. All right, council, we have, just before we begin, I note that we have a hearing set on the break for February 24th at 10:30 on WebEx. Does that comport with the agreement of the parties?
On what day, Your Honor? I'm sorry.
February 24th at 10:30 in the morning on WebEx?
Thank you, Your Honor.
All right, and so it's the intent that the court will issue an oral ruling and a written ruling on that same day. And at that time, depending on how the court rules, will determine what we address next in regards to the motion regarding media in the courtroom. And so we'll take to that point. I do wish to state that this court's mind is not made up and that I would ask all parties to continue in their roles because the court has not issued a decision in regards to the disqualification of the Utah County Attorney's Office. So I would ask that all parties continue to move forward diligently as they have and have made a note of that. All right, so it's 4:37. My lawyer math, let's see. It looks like you would get 10 minutes each for your arguments, and we will end at 5. And if you want to reserve time, you certainly can do so, but take that into account when you're making your argument. Mr. Novak.
Thank you, Your Honor. Your Honor, there are legal issues and there are factual issues that we think that the court needs to look at very closely. I would ask the court, because I only have 10 minutes, to look at both the briefing in the original motion, and I will point out some specific cases that we think the court should pay attention to, as well as the briefing in the what I'm going to call the renewed request. And they're both informative. The briefing in the renewed request doesn't just go to the question of should this court encourage, that's the language that the statute hints at, the state attorney, the county attorney to refer this to the attorney general, but it also refers to when a trial court does or does not abuse its discretion with respect to recusal. The last witness, and I'm gonna just go with the principle of recency here. The last witness's primary purpose was to focus on this question of whether the adult child student at UVU is what the state has referred to as a material witness or a critical witness. And that is actually either intentionally or unintentionally a distraction from the real question here. This is not a question of whether, in order to prove its case, the state needs to call as a witness a family member of the prosecution, okay? That could, in another situation, be a source of a conflict. But the issue here is that the most experienced and most senior prosecutor in the office, other than the elected county attorney, Mr. Gray, should have been walled off from this prosecution until this court had an opportunity to consider whether disqualification is necessary. And it is important to note a couple things that Mr. Garnander said. One of them was that he'd never seen, in his experience, a decision to seek the death penalty made without regard to information about the accused. And there's a hint there that there was an emotional response to Mr. Kirk's death, which there's a strong implication creates an appearance of impropriety. And so this court doesn't have to make a finding that there's a conflict of interest, an actual conflict of interest. What the standard says, and that's the standard that Mr. Gray read into the record from the organization of Utah prosecutors that he's the president-elect of, which refers to the public perception of the integrity of the prosecutor's office and the public confidence in the handling of the case. Okay, so that was standard 1.3-3C. The failure of Mr. Gray to at least temporarily wall off Mr. Grenander, to seek guidance from any other prosecutor, ethics expert, the court, the state bar, people who are leaders or members of SWAP, the Attorney General's office, casual approach to this issue. And it also demonstrates that what Mr. Gray did is he put his need for Mr. Grenander to lead this case ahead of the ethical consideration of whether that might create an appearance of impropriety. Not an appearance in Mr. Gray's opinion, not an appearance in Mr. Grenander's opinion, but an appearance in the public eye. And that's actually your honor's project, if I may, is to determine what a reasonable member of the public would think of this scenario. The other thing that is important here is that we are dealing with a proceeding where the Eighth Amendment to the United States Constitution and the parallel constitutional right in Utah require, and this court has heard it already, and the court's going to hear it over and over again, a heightened standard of reliability. This is not just a court proceeding, and it's not just a criminal proceeding. This is a capital proceeding, which is at this point in time sort of almost the only proceeding where the Eighth Amendment comes into play. And so this court needs to view the appearance of impropriety under this heightened standard of reliability. A couple Utah cases that I think that this court, we would ask this court to look at very closely. State v. McClellan, Utah Supreme Court, 2009, Utah 50. State v. Cater, C-A-T-E-R, 2014. I'm sorry, yeah, that's a Court of Appeal decision. 2014, Utah Appeals 207. Mr. Gray should have implemented a firewall, and he didn't. And that has created this problem. And then what we see is isolating Mr. Gronander's daughter from the investigation, isolating her in some way so that she hasn't provided a statement, she hasn't provided videos until we bring this issue to the court's attention. The decision as to what charges to file, the decision as to whether or not to seek the death penalty should never, ever have been made in consultation with Mr. Gronander, even if he's the most experienced homicide prosecutor in the office, even if he has one of the longest tenures, and even if it's Mr. Gray's ultimate decision. Because now we don't really know, and the court doesn't know, and the court just can't defer to the prosecution. That's the whole point of the court having the supervisory power over this issue. What influenced Mr. Gray? I would also point out that Mr. Gray did not disclose until asked, while under oath, that two members of his faith community were also present there. That was not disclosed to us when he found out about it, and that he has a relationship with the family of some young person who was also negatively impacted. This line of sight analysis, this PIE that has been diagrammed is not the question. That is not the question. The question is whether Mr. Gray should have isolated the prosecutor whose child was there, and I say this with all due concern and respect, could have been injured in any number of ways. People could have been hurt leaving the scene. And I'm not saying that in any way to minimize the effect that that experience had on Mr. Gronander and his family. I think, as I said in court last time, I've been through this where I learned that my child is somewhere where there was a shooting. And until I knew my child was safe, that was, an overwhelming emotional experience. So the problem is that Mr. Gray approached this in an incredibly casual way. There isn't a single memorandum, he testified to this, documenting the process of whether there's an actual conflict or an appearance of conflict. The mere disclosure of it to us and us bringing it to the court does not wash this clean. That is our concern. I also want to cite the court, because I'm running out of time, to a decision that is not a Utah decision, but it's cited on page 12 of our motion, which is Tate, 925 Southwest 2nd, 548, a Tennessee decision, where basically the court says where there were no screening procedures and the prosecutor, as to whom there was an appearance of impropriety, maintained the role of a supervisor, and there was open discussion of the case with him, there should have been a disqualification, and what the court did there is it disqualified the entire office. So this problem could have been avoided if Mr. Grunander had been screened off, if Mr. Gray had sought this court's guidance early. The state, I'm sorry, they were in court on September 16th. This could have been brought to the court's attention in September. Counsel were appointed shortly thereafter. We could have addressed this a long time ago. And now, frankly, it's too late. So we understand that there is pressure on the judicial system to move this case expeditiously. There is also a countervailing, and we believe, stronger need to make sure that there's a heightened standard of reliability, that there is no conflict, and that there is no appearance of conflict. And if that takes a little bit of time for another prosecution office to get up to speed, the investigation is going to continue, the discovery production is going to continue, the lab work is going to continue. None of that is going to change. So we would ask the court, I'm not reserving any time in rebuttal. I'm going to ask the court to grant the motion, both parts of it, which is to make a finding that Mr. Grunander should have been walled off and that Mr. Gray's failure to do so, and sort of the casual way that Mr. Gray approached this whole thing requires, unfortunately, the disqualification of his office and the appointment of a new group of prosecutors to be responsible for this case. The case will continue. What we are asking the court to do today does not in any way change the fact that Mr. Robinson is charged. He's charged with an aggravated homicide. We all have to deal with that, but we have to deal with it in a way where there is no question that the decisions that have been made or decisions that will be made in the future, which is some questions that were brought up to Mr. Gray by his own counsel, and the public's confidence in the outcome of this case are tainted by what should have happened and did not happen. And I appreciate the court's time.
Thank you, Mr. Novak. To the state, looks like Mr. Novak took 13 minutes.
I'll pay you back later.
Thank you. To the state, I will afford you that same time frame. If you want to take all 13 less, I'll leave it to you.
I know everybody in here is going to blame me if they don't leave at 9, which is 5 o'clock. So the reality is, Your Honor, the adult child is not a witness here. She didn't see Charlie Kirk get shot. She didn't record him get shot. She didn't see his wound. She didn't see him get carried off. She's just not a witness. And as a result, there's really no conflict here. Now, I understand that conflicts go beyond just that, but most of the cases that we look at where there's some kind of conflict are where there's confidential knowledge that has been obtained by the prosecutor, right? A defense attorney becomes a prosecutor and now has confidential knowledge about that person, right? That's the typical conflict we see. Has some kind of proprietary or financial interest, right? That's the kind of conflict we usually see. Occasionally there are personal conflicts, but there's a lot of good case law that talks about what kind of conflicts constitute that personal interest. And I think the best case law on this is cited in our opposition to the renewed motion to refer the matter. And in that case, State v. Newman, the court found, this is a Missouri case, the court found no conflict of interest in prosecuting a defendant for murder, even though the prosecutor had done business with the victim, knew him personally, and served as a pallbearer at the victim's funeral. In the Gwinnett County District Attorney, nor his Georgia office had a conflict of interest, even though his chief investigator dated and later married the victim in a case that the office was prosecuting. In Kansas, prosecutor's office did not have a conflict, even though the defendant threatened to blow up the very courthouse and also housed the district attorney's office. I mean, these are cases where the prosecutor has a close relationship with the actual victim of the crime. Look, if Mr. Grunander were related to Charlie Kirk, we would acknowledge there's a conflict here, right? But we're not even close to that. The adult child is not even a witness in this case, is not a witness to the murder. Is the child a witness to the circumstances? Sure, but so are 3,000 others, as well as dozens of video recordings. She's not a witness. She's not necessary in this case. And as a result, there's no conflict here. Now, is he going to be motivated because she was present? Is he somehow going to be motivated to do something he otherwise would not? Well, again, maybe if she were injured, maybe so. Maybe there would be a good argument there. Maybe it still doesn't rise to the level of these cases that I've talked about. But that's just not the fact. She has not been traumatized. She has not had to seek therapy. She has not had to miss class. It's not affected her friendships. As a result, the idea that Mr. Grunander is going to be motivated by some kind of retribution for what happened to her is just flatly false. The idea that the defendant was charged for killing someone because a prosecutor's child was present when it happened is just, it's almost laughable. He's being prosecuted for killing someone because he killed someone. At least that's what the evidence will show, we believe. The idea that he has been, the death penalty has been elected because a relation of a prosecutor was there is just laughable. It's because someone was shot and killed. That's why the charges were brought. I just don't think that proposition is palatable at all. The evidence is what this case was charged on, both at the charging level and at the death penalty level. None of this was motivated because of some relationship. And I think that anybody who looked at this would agree that you don't charge someone with murder because a witness was affected by it. You charge someone with murder because someone was killed, right? The standard. The defense has tried to elevate the standard here by looking at best practices, the SWAP's Statewide Association of Prosecutors best practice. Even so, I think it's been misstated. The standard says that when there's an appearance of conflict, the prosecutor should, I quote, consider recusal. Well, that's the question. They should consider it, right? It doesn't say it mandates recusal or disqualification. And that's not even the ethical standard that this court goes by. That's the best practice. And the best practice was followed in this case because once that fact was known, there was a discussion. Of course, it was disclosed immediately. It was disclosed 5 days after defense counsel was appointed. The idea that the child was isolated is just flatly false. She just was not a witness. And the follow-up with her showed as much. The standard is there a significant risk that representation of the state will be materially limited by a personal interest of the lawyer? In this case, the decision to prosecute and the prosecution of this case will not be limited in any way. Moreover, if anything, the interests would align. Regardless, the motivation here is clearly not because of the presence of this child. It's because Charlie Kirk was murdered in front of everybody. She's not a material witness. Everybody knows Charlie Kirk was shot and killed and murdered brutally. Everybody knows that. I don't think that's going to be what this case is about. It's going to be about identity. And neither the child nor any of the other 3,000 witnesses present really have a whole lot to say about who this was that did the shooting. And that's what this case hinges on. There's been no evidence that Prosecutor A's child had any effect on the prosecution of this case to date. And there's no reason to believe it will have any effect in the future. The testimony was clear that no one anticipated that based on her lack of value as a witness and the lack of trauma or injury to her there really shouldn't be any question about that for this court, for the public, or anyone else. Thank you.
Thank you. Thank you to all parties. I acknowledge the hard work and effort that went into today, and this court appreciates that. We will reconvene on February 24th at 10:30 in the morning via WebEx. And just for clarification to defense, in regards to Mr. Robinson, how would you like Mr. Robinson to be present at that hearing?
Your Honor, Mr. Robinson, I believe it's WebEx for everyone, right?
It is.
He can also be on WebEx. Your Honor, we would waive personal appearance for that.
All right, thank you. All right, with the new date set.
Wait, I'm sorry, just a minute. Oh, sorry, audio only. Thank you from my co-counsel. Audio only, no screen.
All right, I appreciate that clarification.
Thank you, Your Honor.
And with that, court is in recess.
All rise.
10:30?
Oh my golly. Hey, good morning, everybody. Hope you all are staying warm and glad to see everybody. The sidewalks are starting to get de-iced, so that's a bonus, right? But let me comment on today's appropriation vote. No president has been stronger or more consistent on securing the border and removing criminal, illegal aliens from our communities, period. Strongest president ever. I have complete trust in President Trump that he will continue to enforce the rule of law, including each and every one of our immigration laws. So here's what we're going to do this afternoon. One, we're going to pass the legislation to finish funding more than 95% of the federal government at Trump spending levels, not Biden spending levels. And two, on the sliver that remains, we will keep the wheels of progress turning and let the president do what he does best, and that's negotiate a final deal on his signature issue. And I'll tell you what, if anyone can get this deal done that is going to crack down on illegal criminal aliens to protect our community, that's going to be President Donald J. Trump. So with that covered by our president, House Republicans are remaining focused on Americans' pocketbooks. Tax filing season began last week, and thanks to House Republicans, it's going to be easier than ever for working families to file their taxes. And why, you ask? Because Republicans expanded the standard deduction. To put it in plain English, the first $31,500 a family earns is tax-free. So the first $31,500 of every family, tax-free. And that does something else that's very important. It saves you time. About 210 million hours of paperwork gone. And that's 210 million hours and 210 million hours of time that the Americans people can spend on doing what they want to do, not filing their tax returns, burdensome tax returns. But here's what's really important that's missed. Every single Democrat voted against that $31,500 standard deduction. Every single Democrat voted against saving you time and making tax filing easier. And every single Democrat voted against saving you money. Remember, and I say this every time I'm up here, and one of these times it's going to get covered by y'all. Every single Democrat voted to raise every single American's taxes. I'm going to say it again. Every single Democrat voted to raise your taxes. Please highlight that in your stories. I mean, I would think the Democrats would be proud to raise your taxes. They need to own that. Republicans are saving you time and saving you money. So this week, House Republicans are taking that message directly to the people. All across the country, we're reminding Americans exactly what happened and the impact that it will have on their families. Simply put, Republicans voted to make tax filing easier, less bureaucracy. That's a good thing. Republicans voted to cut taxes for working families to keep more money in your pockets. Democrats, again, voted against that. Democrats want more bureaucracy, and Democrats want more of your hard-earned tax dollars. Democrats want to raise your taxes. Republicans want to lower costs and keep more money in your pocket, simply put. So now I will turn it over to our whip, who's done an amazing job, Mr. Emmer. You can raise this. Without squeak. Oh.
We need some Earl.
Yeah, there's funding for that in the bill.
There. Now I can actually see what I've got.
Once again, Republicans are making clear that we are the party of responsible governance. While Hakeem Jeffries foolishly urges his members to hold the American people hostage for the second time in less than 6 months, House Republicans are preparing to vote, as we've already done, to fund the government with individual appropriations bills. We passed these bills once before, and we will pass them again. As promised, Republicans in the House have reclaimed the power of the purse. 11 of 12 America First spending bills have passed through both the House and Senate, and now we're going to finish the job. That's what governing actually looks like. The American people deserve a functioning government, and House Republicans will deliver. Just like the Democrat government shutdown in October, Hakeem Jeffries and far-left Democrats want a political show. What's their angle this time? Obstructing President Trump's successful law and order agenda. Thankfully, Republicans thought ahead. In response to the devastating Biden border crisis, we proactively funded immigration and customs enforcement operations for the next 4 years in the One Big Beautiful Bill. The Democrats' attempts to stifle immigration enforcement and protect dangerous criminals, especially in my state, will prove to do nothing more than hurt law-abiding Americans. Some in their party actually know this, and we hope they will do the right thing. But even if not, law and order and responsible governance will prevail thanks to Republican leadership and despite obstructionist best efforts. We must get this government funding bills to President Trump's desk swiftly for the good of the American people. And with that, I turn it over to our leader, Steve Scalise.
Thank you, Whip. Well, look at that.
Is that a bird?
Whoa, it's like autopilot here. We've got a runaway podium. The Democrats have tried to shut this thing down too. Once again, today, Republicans will reopen the government after Democrats shut it down. It's like we've seen this movie before, just a few weeks ago, that Democrats shut the government down for a record amount of time. And it took President Trump working with Republicans to finally get it reopened. And we're going to do that again today. And as the whip said, if some Democrats want to join us, we welcome them. But you've seen their leaders, like Hakeem Jeffries, say they want to keep the government shut down. And you'd ask why? Well, it's surely not over ICE, because we've already funded ICE in the One Big Beautiful Bill. But what does a no vote mean today? If Democrats like Hakeem Jeffries vote no today, they're voting against a 3.8% pay raise for our troops. That's in this package. What they're saying is they don't want our troops to even get paid, let alone get a pay raise. Because as it stands today, troops will not get their next paycheck if Hakeem Jeffries and Democrat leaders get their way. TSA agents who keep our airports operating so people can go see relatives flying around the country, that will shut down if Democrats vote no. FEMA is right now giving aid to a lot of states that have had massive damage from freezes. Democrats voting no shuts that down. And so Republicans will be the responsible party once again to keep the government open, to reopen this government and focus on the priorities that the voters elected Donald Trump and House and Senate Republicans to go implement. We will keep doing that work, even with a razor-thin margin. And I know, yes, sometimes the odds look lower than the Patriots winning the Super Bowl, but that's okay because we are here to do a job, and we're going to do that job. And whoever wants to join us on the Democrat side is free to. And look, we've been able to deliver a lot of bipartisan wins on a number of areas. If you look at holding people accountable, Chairman Comer's right now in the middle of a negotiation with the Clintons. Bill and Hillary Clinton were subpoenaed on a unanimous vote, Republicans and Democrats voting unanimously, which almost never happens in the Oversight Committee, and it did, to say they have to come forward and testify over the Epstein files. And they have been refusing and refusing for months. And finally, at the midnight hour, when a contempt resolution is sitting over their heads, did they finally start talking, but they are not in full compliance. They have until noon today to fully comply. Otherwise, we will move contempt tomorrow against the Clintons. And again, That was a bipartisan vote out of committee to say that nobody's above the law. The Clintons have to comply with the subpoena like everybody else. I think it was Jamie Raskin who said, when you're subpoenaed by Congress, you have to show up. We'll see how he votes on that tomorrow if the Clintons fail to comply. But we're going to keep doing our job. We're also bringing an important bill on critical minerals to the floor to open up the vast resources of this country that have been shut down by the previous administration so that we don't have to be reliant on countries like China for the critical minerals that run so many of the products we use every single day. This Republican majority is going to keep delivering for the American people while we meet the basic obligations of government, like keeping the government open and reopening the government, which we'll do today. The man at the head of that effort is our great speaker, Mike Johnson.
Thank you, Steve. Well, all right. It's not on autopilot anymore.
You love doing that.
I do. Makes you feel taller. So grateful to be with you all, and I'm sorry we're in this situation again. It's like Groundhog Day in a way, the bad movie, where we come back to the same failed measures of the Democrats. It was just less than 3 months ago that they shut the government down for the longest period in history, 43 days. It was painful for so many Americans. Finally, a handful of them saw the light and helped us to get the government operating again. Republicans have demonstrated over and over that we are the grown-ups in the room. We are the ones that are governing. We are the ones that are funding the government. We are the ones that are providing the vital services and trying to make government work more efficiently and effectively for everyone. After that long historic shutdown that was so painful, appropriators in both parties got together. I tip my hat to Chairman Tom Cole of the House Republican chair of the Appropriations Committee and all of our committee members, the Cardinals, the subcommittee chairs, as we call them, all worked so well in their areas, and we got 12 separate appropriations bills passed through the House, and we had a triumphant press conference announcing that. We expected it to be on a glide path through the Senate, but of course the Democrats could not miss an opportunity to try to shut the government down again. That's what they're doing. Chuck Schumer and the Senate Democrats play games with government funding. Now, listen, the president obviously has reached out to state and local officials in the state of Minnesota. The events there have been tragic and unnecessary. He's made clear his desire to de-escalate the situation and to support an honest investigation of what's occurred there. We now have Tom Homan in charge of operations there, and he's an extraordinary leader. He has 40 years experience. He's highly decorated, has worked in Democrat and Republican administrations, and knows what he's doing. And there's more order being brought to the chaos. Now, I want to hasten to say that the chaos is because, in large measure, the local and state officials in Minnesota have not been participating with federal law enforcement operations. And they've created a dangerous situation there. And that is really a big part of the problem here. The White House and the Senate continued in good faith. They've agreed to separate the Homeland Security funding bill, and that's fine. So we have 2 weeks now to negotiate in good faith on both sides. The White House and Senate Democrats are going to engage in that, but the House Republicans are as well. We have to make sure we maintain the important parameters here. We can't go down the road of amnesty. You can't in any way lighten the enforcement requirement of federal immigration law. That's what the American people demand and deserve. We want dangerous illegal criminals to be sent out of the country, and they've been very successful at that. But these negotiations are going to go forward. If the Democrats do insist on keeping the government shut down, their pointless obstruction is going to have no effect on border security, which we have done, we've secured, or immigration enforcement. As has been noted by the leaders here this morning, we did fund ICE operations for a few years now. So what they'll be shutting down, don't lose this, what they'll be shutting down is FEMA operations as we're cleaning up from the winter storms. They'll be shutting down TSA, which is obviously necessary to keep the country moving through our airports, Coast Guard operations. I mean, so many important functions in the Department of Homeland Security is what will be adversely affected by these partisan games. Let's hope and pray that they don't do that. Let's hope that over the next 2 weeks, we can negotiate and get this done. They say they want a real negotiation with President Trump and Republicans over immigration enforcement policy, and we are happy to have that debate. And I've said in a gaggle earlier this morning that what must be a part of that discussion is the participation of blue cities in federal immigration enforcement. You can't go to a sanctuary city and pretend like the law doesn't apply there. It does. And so we're going to be working through all that. Our chairwoman McLean talked about tax filing made easy. Last week marked the beginning of tax season, and millions of American families are working through that right now. And they're recognizing the amount of time and money spent complying with the federal tax code is going to be significantly reduced this year because of great Republican policy. Some of the things we did in the Working Families Tax Cuts, the big, beautiful bill, obviously we intended to cut taxes and to advance America First pro-growth policies, but we also sought to reduce the tax burden on Americans because we know that reforming the tax system isn't just about reducing rates. It's also about reducing the paperwork and the compliance burden on Americans. And you heard these stats, I'll repeat them, but our Working Families Tax Cut locked in the doubled standard deduction. It boosted it further to $31,500 for American families. That's a lot of money to hardworking folks. And again, we remind you, Democrats voted against all of those great reforms. These successful reforms are going to save Americans 210 million hours per year in paperwork and $13 billion in compliance costs. That's real money to real people. We're proud of that. Nobody likes paying taxes, okay? But Republicans have reduced the amount you owe and made your returns significantly easier to file. And so we're so grateful everyone's going to be able to take advantage of that. Last thing I just want to mention, and we'll take questions. I don't think the American people need any more evidence. The Democrats want to tax the American people to death. Just check congress.gov. You can see all the bills they filed. But if they did, they should look no further than the Democrat-run D.C. Council's decision, listen to this, to decouple the local tax code from specific federal tax provisions. So in layman's terms, what they're trying to do here, any Democrat-run city is going to lead into this kind of nonsense, but they're preventing DC residents from experiencing the full benefits of the Working Families Tax Cuts bill. It's almost unimaginable that they would inflict that pain upon their own constituents, but that's what they're doing. DC is not alone in this obstruction. You've got strongholds, Democrat strongholds like New York and Colorado and Illinois, cities there, preventing their residents from enjoying these benefits. There's no way to spin it. Blue state governors intentionally harming their own residents just because the policies were offered by a Republican administration. I mean, that's what's happening. And it's just incredible to us. Is there any stronger evidence that Republicans are the party of affordability? Democrats say one thing and they do completely the opposite. And I'm so sad for you if you live in one of those jurisdictions. It's a real problem. If this act were to become local law, DC residents would be prevented from claiming no tax on tips, no tax on overtime, the increased standard deduction, and so much more. It's just wrong. There's an estimated 17,000 tipped workers here in the nation's capital, and the DC City Council is attempting to prevent them from enjoying this historic tax benefit. But House Republicans are going to work to fix it this week. We will advance Representative Gill's legislation to disapprove of that nonsense at the DC Council, because every American deserves to enjoy the benefits of the Republicans' historic tax cuts, even if you live in a Democrat stronghold. Take a couple questions. Yeah. Bill, go ahead.
Thank you, Speaker Johnson. Are you confident you have the votes for this rule book to pass, and do you expect any Republican no votes at all?
I don't, and this may be hard for some of y'all to believe, but I never doubted this. This was not this is not my preferred route. I wanted to keep all 6 bills together. We worked so hard to pass them through the House, and I thought that should have been a package that sailed through the Senate, got to the president's desk so we can fund government responsibly. We're spending less money year over year, and we're returning regular order around here, and that's a commitment I made when I became Speaker, and we're finally getting it done. But listen, the president agreed with Schumer that they would separate Homeland, and we'll do that, and we'll handle it. We're going to pass the rule today. It was never in doubt to me. The Republicans are going to do the responsible thing. I did talk to Hakeem Jeffries over the weekend, and he informed me that they would not be assisting in this endeavor. And I just think that's crazy. I mean, I just think that everybody needs to look at what's happening here. One party is moving forward, by the way, with the smallest margin in U.S. history. We have a 1-vote margin. We are still sticking together. The Republican Party is sticking together because the stakes are so high. We're governing responsibly, and we're getting the job done. And Democrats, all they do every single day here is obstruct. And you can see the record for itself. They shut the government down for 43 days, the longest in history, just last fall, and they want to do it again. And it's just crazy. And I think the American people are going to think about this hard when they go to the voting box and to the ballot box in the fall, and we decide who keeps the majority in Congress. I think they're going to give it to the grown-ups. I think the Republicans will be able to continue and grow our majority to keep governing. Otherwise, what Democrats will give you is chaos, shutdowns. They'll shut down the federal government. They keep proving it to you over and over. So take them at their word.
Mr.
Jay.
Speaker.
Explain this. So Jeffries told you he wasn't going to help with this. Did Schumer represent something different to you in your conversations with the president? Because it seems that there's a disconnect here that's hard to square.
It is hard to square, and it's not my place to get involved in their family squabble. But I mean, I think Hakeem has made very clear. I think he was upset, offended that Chuck Schumer presumed to speak for House Democrats. So you'll have to figure that out. The Democrats are in a family squabble over there, and it's not of our doing.
Mr.
Hold on,
Speaker.
wait a minute. Schumer and Jeffries are from the same state. They're in the same delegation, and they seem to be having a little power struggle between the two of them. So look, I'm not trying to fuel that. You asked me the question. I don't know what's going on, but I can tell you the Republicans are united, and I'm proud of that. And this is the party that is getting the job done.
Mr. Speaker.
You're a constitutional lawyer. Can you detail the Fourth Amendment protections and rights someone has if an ICE agent approaches their home with an administrative warrant?
Yeah, right. Let me say this. Okay, so when ICE goes to execute a warrant, it's an administrative warrant and it's issued by an immigration judge. And that is a sufficient legal authority to go and apprehend someone. They have violated the law. They crossed over our border illegally, and they're here and without any right to be here. Okay, that's what's happening now. The controversy has erupted where if someone is, they're going to be apprehended and they run behind a closed door and lock the door. I mean, what is ICE supposed to do? What is Immigration Customs Enforcement supposed to do at that point? Oh, gee whiz, they locked the door. I mean, I guess we'll just go on to our, so there's some logic and reason that is to be applied here. Some have complained that the force has been excessive or what have you. I don't know. We're going to figure that out as part of the discussion over the next couple of weeks. I'd tell you what the Democrats want to do and what we cannot do. And that is they want to add an entirely new layer of warrant requirement. Okay, they want to have a judicial warrant on top of the immigration judge warrant. And we can't do that. Just think of it logically. Okay, you've got maybe 20 million illegals who came across the border just in the last 4 years when the Biden-Harris administration opened the border wide. Okay, imagine if we had to go through the process of getting a judicial warrant, an additional warrant to go and apprehend people who we know are here illegally. How much time would that take? We don't have enough judges. We don't have enough time. It would take decades probably to do that. The people who are advocating for that don't want any immigration enforcement. They do not want anybody to be sent out of the country who's here illegally. And that is blatantly what their cause is. So we've got to apply reason. We do have to apply the Constitution. We have to respect it. And those parameters need to be determined. But I can tell you that we are never going to go along with adding an entirely new layer of judicial warrants because it is unimplementable. It cannot be done, and it should not be done, and it's not necessary.
Mr. Speaker. Mr. Speaker.
Thank you, Mr. Speaker. Good morning. In 2023, I remember this, you chaired a hearing after the FBI had that raid on Mark Hope, the pro-life father.
Yep.
And that was something that I think to this day, Republicans say was a problem in the use of force by this government.
Yeah.
And my question now is obviously we understand ICE's legitimate purpose, but we've seen guns drawn on Americans who have not necessarily protesters. We've seen people pulled out of their houses, to your point about the warrants. Do you think ICE needs to change, and CBP, any of their tactics, given what your concerns about civil liberties from the past?
I have great faith and trust in the leadership of Homeland Security and Tom Homan in particular, who's now in charge in Minnesota. He brings 40 years experience to this. He's very measured. We all believe that immigration policy ought to be balanced and strategic and smart, and it obviously needs to comply with the law. And I'm going to leave it to the experts to determine what that is. I think in the negotiation, I think we've got to remove the politics. We've got to look at what the Constitution says, what federal immigration law says, And if anybody wants to adjust immigration law, then that's why we're here in the legislative branch. But we need it. We need that approach. We need the temperature turned down. That's the president's words. And you need a steady hand at the wheel. I think.
Do you have any
Mr.
concerns?
Speaker,
Mr. Speaker, you
Speaker,
have a
Speaker,
question.
yeah, I just want to circle back on the judicial warrant situation. Can you just explain to me why we're talking about adding additional requirements? Adding a judicial warrant is adding an additional requirement to this process. I mean, immigration advocacy groups for years have said, don't open the door for immigration agents without a signed warrant from a judge. ICE's own field manual says entering a home without a warrant is typically a violation of the Fourth Amendment. How is this raising requirement? Isn't this the MO for how things normally work?
No, I mean, look, the question is to the Democrats who are ringing the bells and saying that they're trying to make this one of their demands in this negotiation. That's what I'm told. Some of them have. And I'm saying that is a road that we cannot and should not go down. And to your point, ICE, for many years, obviously, has had in the manuals that you follow the Fourth Amendment restrictions and you do this in a meaningful and thoughtful way. But we have an unprecedented level of opposition and pushback. When you have local and state officials informing their citizens that they should impede the immigration, customs, and enforcement operations, it creates a dangerous situation, and that's what's led to all of this chaos. If the governors and the mayors in the blue cities and states would participate with federal law enforcement, we wouldn't even be having these conversations. I mean, you would have a much smoother process, I think. So, look, we're going to have all these discussions over the next couple of weeks. We will figure out a path through this, but we have to enforce our immigration law. The American people made that the number one issue in the last election. The wide open border and the chaos that ensued because of it was the number one issue. The president got to work. We used the existing law that was on the books, as we always said, as I said, for 4 years under the Biden administration could have happened, and we closed the border tight. In just a couple of months, we've had almost zero illegals released into the country since President Trump took over. Strong leadership. And the next commitment was, as we said to the American people, we will get the dangerous criminal illegals out of the country. And that's what they've been doing. And for anybody to impede that, they are impeding the will of the American people. They are creating a more dangerous situation on our streets, and it has to stop. So stay tuned for the rest of this. We'll get into the details of it. I'm just telling you that adding a whole new layer of judicial warrant requirements is an unworkable proposal. And I think the people who are making that suggestion understand that. I don't think they want anyone to be apprehended inside of the country. So
Mr. Speaker,
Is
Mr. Speaker.
there a question about elections? Happy belated birthday, Mr. Speaker.
Happy belated birthday.